I'm Lloyd Copenbarger. Philosophy has been that if you serve people, the finances will take care of themselves. Every morning when I get up and I look in the mirror, I say to myself, today you're going to help some people.
I believe in Lloyd's mission. Lloyd's mission from the very beginning was serving families who needed to protect the resources and the relationships that were important to them. We've served over 30,000 families. So when people ask me why I'm here, I truly believe in the future impact that this firm can make.
It's really important when a client comes in that they don't feel like we're trying to just shuttle them out the door, that it's a long-term relationship.
It's estate planning, but it's personal. And we're able to minister to that person and give them counsel and give them guidance and let them know they're not alone.
When we first walked in the door here, we just felt so at ease. They greeted us really in a wonderful, welcoming way.
We just had a much more positive experience than we have had elsewhere.
One of the things that we are known for is the fact that we have always put clients and their needs first. So service is extremely important to us.
As I was getting older, clients were looking at me and saying, hey, your hair's getting gray. I think you're going to retire. And I looked for years, Copenbarger.
I've learned over the years that you do business with people you like and you trust, whether it's the gardener you're hiring or it's your surgeon and certainly an attorney. And what we found when we walked through the door was that pretty much immediately we loved the people here. And that's why we chose Copenbarger.
Without our team of people, we're nothing. We have the best attorneys you can ask for, the greatest education and credentials, but without that team of people, we're not anything.
So not only are you servicing the client, but the fact that everyone cares about each other unites us as one group, and it's pretty exciting to be on a team like this.
The Copenbarger firm is an outstanding firm. They are very generous, they are the most kind people, and they have done an outstanding job for my husband and I.
It was some 20 years ago, we made an appointment and we came to the office, and that's when we met Larry Copenbarger, who was an outstanding man.
We have become a family over the years.
I was really taken by his hospitality, his warmness, and that's how we became friends.
We're keeping that in mind when we're bringing new staff on board, that they recognize that in order of priority, it's serving first. So it's not just about their technical skill, it's really about making sure that they're a good fit culturally, and that's what's ultimately going to lead to a successful transition of Lloyd's legacy.
Someday I'm not going to be here anymore, but the people who have relied on our representation will be. And I know the people that are the clients of Copenbarger,
They feel like they're cared for here, and I think to come in and want to change that, I came here because I want to care for them and I want to keep this legacy going.
It gives you a great sense of satisfaction that what you're providing to your client cannot be surpassed. Maybe equaled by some law firms, but definitely not surpassed.
I'm very, very confident in the work that they do here, and my experience has been tremendous.
I believe sincerely when I look at the future possibilities of this firm that we can impact thousands of families, just like we have in the last 40 years.
Every night when I go home and I look in that same mirror, I can say to myself, you had an impact in some people's lives today that will make their lives better. Now, how does it get any better than that in life?
Good morning.
Good morning.
It's a mic drop moment.
This one was more enthusiastic. All right. Can everybody hear? Okay, thank you. In the back in particular. Anybody not able to hear? Okay, perfect. All right, well, welcome to our 2026 Santa Ana seminar. Thank you guys for taking some of your time out of your day to be here with us. For those of you who have been to a seminar, what I'm going to say next is not going to be surprising. For those of you who haven't, we go through a lot of information at these seminars. We cover a lot of material in a relatively short amount of time. And so what we encourage you to do is use the handouts that you have at your seat. The handouts go through all of the slides that we will be showing today. This is also being live streamed and will be posted to our YouTube channel, so if you need a refresher on anything we talk about today, you can always watch it back. But one of the things we find with those handouts is it's a great place to flag a question, because if you come and have a consultation with us, that is the moment that we want to hone in on what stood out to you today beyond the general. So again, I very much encourage, take notes in that thing, jot down, I have further questions, does this apply to me? That way, again, in the consultations, we can get more to the one-on-one side of it. Now, for those of you who don't know us or have not seen us in a while, what you will see here is we have a very large group of attorneys and officers. So what that means, we are one of the largest, if not now the largest, estate planning firms in California. And the reason is we do more than the estate planning side of things. Estate planning is the foundation of what we talk about, and it's a very large component of what today we'll address. But we also know that at some point, that plan that we have set up will need to be executed after we have passed away. And that is where our estate administration team comes in to help walk alongside the family. Now, anytime someone passes, nobody wants to deal with legal. I cannot imagine one person who says, yay, my loved one passed and let's go talk to an attorney. But the reality is the law and the trust do require things that need to be done. And so that team is there again to actually do those tasks if your family would want that. We also have our business and tax department. So if you have rental properties, if you have higher net worth, if you have a business, small, medium, or large, if you're just concerned about how to preserve your estate from higher taxes, that is where the team from business and tax is going to come in, and you will also hear from them today. Most of what we talk about is how to avoid the court, how to avoid litigation. But unfortunately, we know no matter how much we plan, no matter how much you plan, things can happen beyond our control. And so if that does become a reality, we also have our litigation team to step in and help walk alongside you and navigate that process. And we could not do what we do as attorneys without our incredible staff. So you have seen a number of them today who are walking around helping check you in and make sure these events run smoothly. We are absolutely a team, and so when you work with an attorney, odds are you're going to have quite a team behind you making sure things get done. And then we have offices all over the state. Now, most of you, if you're sitting here today, would likely go across the street to our Orange County Santa Ana office that's literally right across. But if you're not comfortable coming in person, it's not going to be convenient. Maybe you don't actually live here and you're just visiting. We, again, can have offices and in-person appointments all over the place. We can do Zoom and we can do phone. So we're very accessible. We understand that not everybody is going to be physically in a location. All right, let's jump in. So as I mentioned, we go through quite a bit. So I will be covering this first section, which is estate planning essentials. So for those of you who already have an estate plan, this will be a very good refresher course on why the plan you have is so important, but also why it is imperative to keep it up to date. For those of you who don't have a plan, this will be a really good crash course of why you need one. One of the things that we really emphasize, though, is, again, especially for those of you sitting here with a plan, it is very important to remember that that plan does need to be taken out and looked at periodically. We recommend you come and see us every 3 to 5 years, not because we're expecting changes are always happening that frequently, but as your life changes and as the law changes, again, it is imperative that that plan stay up to date. So let's talk about what that plan is. When we're talking about estate planning, it is not just one document. It is a comprehensive set of documents, all designed to protect you, your estate, and your family from different, what we'll call predators. Because we're not just talking about what happens when you die and where does your stuff go. We're also talking about what happens if you're alive, but you can no longer communicate medical wishes. What happens if you're alive and you're incapacitated and you can't manage your money? Who can actually do that for you? So I believe everybody except maybe one person I saw is over 18 today. All of you need a healthcare directive. So if you are sitting here over 18 and you do not have a healthcare directive, that is one of the most important documents to make sure you have in place. Because once you turned 18, everyone lost an automatic right to make your medical decisions. What that means is if you can no longer verbally communicate to the physician, it needs to be in writing who has that authority. Because not even your spouse has an automatic right to go in and start making decisions for you. So not only is it important to have, it's also important that your document was done since 2004. If you have a document for the healthcare directive that has a date pre-2004, it is no longer valid. So again, it's important to take those out and say, hey, is it still up to date? The other thing though is when you have your healthcare directive, if or when it becomes needed, you're in likely a very vulnerable spot because it is now the document communicating for you. It is now the document giving somebody else the authority to communicate for you. So it is again important to make sure the who is communicating for you piece is still current. Maybe the people you had named have moved or passed away. Maybe your children were minors when you first set it up. Now they're adults and they are the people you would want to start making these decisions. The who component of it is extremely important, again, to make sure is being kept current. The other thing to note is it is extremely important, in our opinion, to have a comprehensive directive. One of the things with estate planning that is hard is, especially now with Google and AI, you can hop online and find a lot of things that are cheap and free. But when you have cheap and free behind the number, unfortunately that means the quality is being reduced as well. One of the things our directive answers is, do you want life support? That is a crucial thing to have had the opportunity to answer ahead of time. Not only for you and your autonomy, but also frankly for the person that you're putting in charge of making that determination. Having lived through that for my grandma, I can very much say it eased the burden of having her have decided that ahead of time. I didn't have to feel guilty about, am I making the right choice? Because the only choice was to follow her wish. So again, it not only continued to give her that dignity, it allowed me to not have to worry, am I making the right choice for her? But sometimes those choices change. So again, the moral of what I'm saying is pull those documents out, take a look at them, and let's make sure they're still current and up to date. If you have Kaiser has started to require specific language about when the person named is allowed to act. If you don't have Kaiser, you can tune out here for a second. But if you do have Kaiser and you didn't get a healthcare done with us in the last about year and a half, come in, let's take a look at it and make sure that that language is in there so that Kaiser doesn't throw up any red tape and ask further questions. Okay, enough on that. The next one that you need is the durable or financial power of attorney. This is for a similar reason. You are in a position of incapacity and can no longer communicate now with the bank of who is able to manage that money. Banks are even stricter than the medical side of things. If somebody does not have legal authority to manage your accounts, that's it. There's really no way around other than unfortunately going to the court, which as I mentioned is something we are looking to avoid. With the financial power of attorney, again, this is who can manage your finances. Now, a lot of times we'll hear, well, my spouse is already on accounts with me. Why do I need to have one of these? Well, there's a few reasons. Your spouse is actually not going to be on all of your accounts if you have 401ks or IRAs. You are the sole owner of those accounts. Your spouse is often only a beneficiary on those accounts, which means if you management authority, again, nobody has that automatic right. The other thing is, what if your spouse passes away? Who then has that authority? So within these documents, we build these contingencies of, okay, if this person can't, who's the next? If that person can't, who's the next? So that you have these layers of protection built in. An important date to note on the power of attorney for finance. It needs to have been done in the last 5 years. Banks, as a result of COVID, reacted to the incapacity increase, which also sadly led to increase in elder abuse and financial fraud. One of the ways they are combating that is to say this document cannot be stale. And they set the term that was about a 5-year period. If it's older than 5 years, especially if it is not your spouse as the primary, but as kids or other people, you really need to ensure that that document is up to date. If you're not sure which document I'm specifically referencing, you're not sure where to check for that, bring your documents in and we're happy to take a quick look and say, okay, it was done last year, you're fine, or we're past the deadline, let's get it up to date. And as I mentioned, one of the concerns is if you don't have these two documents and you become incapacitated, where you can no longer give that authority, unfortunately, the only place we can go at that point is the court to attain what is called a conservatorship. That is essentially where the court is now deciding who has that authority and the scope of that authority. So it is taking a lot of control out of your hands and placing it now in a judge who doesn't know you and does not know the family dynamics. So it is a nightmare. Arguably, conservatorships are worse than court that comes in after you've passed away, Because as horrible as this sounds, at least when you're gone, we're not worried about taking care of you at that point. With a conservatorship, the problem is we're still trying to get you cared for. And until the court gives that person authority, we can have issues getting you medical appointments, getting you prescriptions refilled, getting your bills paid, getting you into the proper facility care. So again, if you take nothing else away, you need the healthcare directive and you need the financial power of attorney, and they need to be up to date. All right. The next question we're looking to answer is, do I need a will or do I need a trust? Now, in California, wills are not used very frequently because they are very restrictive on the assets that they would actually protect if you died. And by protect, again, I mean keep the court away from it. So if you have more than about 2, a will is not going to be enough to keep your estate out of court. Now, especially the piece with property. Most people who own property in California, whether you bought it for $750 is irrelevant. Most properties are worth more than $750 at this point in the state, or at least are on that trajectory. So again, it's not the document that often is going to be enough to fully protect your estate when you pass away. And the issue is if it wouldn't have fully protected, again, we now are going to court, and that is in the form of probate. Anytime, again, the court comes into play, they have the control. They determine who your executor is, they determine who inherits, which again takes all the control out of then the family's hands. If you had a will, that's great, but again, the court still has to say, yes, we're going to follow that because all the boxes were checked. So again, giving the court way more control than we would have needed to. The other issue is anytime court is involved, it's more expensive. It just unfortunately is the way that that goes. One of the things you'll note at the bottom is it says it would cost a percentage of the gross estate. One really important thing there is for your piece of property. They do not at that point care what your equity is. They don't care if you have $1 of equity. If the property could be sold and is appraised at $1 million, they're putting that percentage on the $1 million. So you can imagine if you have mortgages, car payments, outstanding debts, how much a probate proceeding could deplete the estate and leave less to the people you would have wanted. This is just a quick snapshot. One of the things you'll note at the top are attorney's fees. Well, why would an attorney who could get that fee be standing here telling you to avoid probate? The reason is at Copenbarger, we know probate is not in your best interests. And the reality then is, and probate is not that process. So that is where we start talking about how do I avoid that? How do I not get stuck with that giant bill and that nightmare headache? And that is where we talk about living trusts. So living trusts are the main vehicle for their lifetime. One of the main benefits is it avoids probate, so it cuts the court out of the conversation, which also then protects your privacy. Your trust does not have to be produced to anybody other than who is in that document and has legal right to see it when you pass away or become incapacitated. Prior to that period, you don't have to give it to anybody. It doesn't have to be filed with the court, which again retains that privacy component. The other thing is a trust allows for more tax planning. Now, what I hear from a lot of people is, I don't have a super high net worth estate, why do I care about tax planning? The issue, and you'll hear a lot about this from Mark Krause, one of our other planning attorneys, is taxes, whether we like them or not, apply to all of us in one way or another. We'll talk today about property tax. And these are the things that can be done in a trust that without planning wouldn't have that same option. And ultimately, everything again comes down to making sure your wishes are actually the ones carried out, not the court's, not your family's even, but yours. Now, one of the reasons people don't come to see us is they don't know how to answer all of the questions that need to be answered. And one of the big questions is, who's going to manage my estate when I no longer can? And that is in the form of what's called a trustee. Even if you have kids, you might not, so people can get stuck at, okay, now what? One of our jobs is to go through what are some alternative options? What are some things maybe you didn't know were options or you hadn't had a chance to think about? One of our jobs, again, is to go back and forth with you and allow our experience through what other clients have done and through what the law allows to help you jump those hurdles. So if you are sitting here today and you're stuck at one of those questions and you don't know if now is the right time to start planning because you don't have all of the answers, I encourage you to still come in and speak with us so that we can help you hopefully jump over that hurdle and at least get to that next phase. Now, one of the things I mentioned is the trust helps you avoid the court and avoid probate. But one of the key things that needs to happen after a trust is established is certain assets need to actually be titled in the name of the trust. So generally speaking, that is going to be pieces of real property, your checking accounts, savings accounts, and non-retirement investment accounts. Those 4 categories, again, generally speaking, are what we're recommending. Now, everybody is case by case, so if you're not sure if you should be doing that, again, come and see us. But let's say we advise that you put all of your Bank of America accounts into the trust. There was $300,000 spread amongst them. And you forget to go to Bank of America after your trust is set up, and it stays in your name alone for the rest of your life. You don't put the trust on it, you don't put a beneficiary on it, and you die. Well, ordinarily, that asset now is going to the court. And the court ordinarily is going to get to control that asset. But we've created what's called a pour-over will, which is designed to come in and cut the court's access and say, no, court, you don't get to control that. You need to give it back to my trust, and my trust is going to control where that thing goes. So it doesn't keep you fully away from the court. So the perfect answer is your assets are properly titled. But the supplement answer is we've created this safety net, so again, the court doesn't get that full control over an asset, and it ultimately goes back where you had said. If you have a Copenbarger trust, you have a pour-over will. If you don't have a Copenbarger trust, we're happy to review documents provided by other attorneys to make sure you do have all of the protections in place. Now, a lot of what I've talked about is your money, how to protect the true dollars and cents. We very often hear from people when we bring up stuff, and is there anything a person would like? No, my kids don't really want it. If you have heard me speak before, you know my answer is, that is only true because you are still here with them today. For most people, the stuff doesn't have a value until you are gone. And all of a sudden, when you are gone, that thing becomes their memory of you. It's the tangible thing they can still hold on to. I can, again, using my grandma, speak very personally to this. During her life, she would ask, and it felt, frankly, rude to say, yes, Grandma, let me have this when you pass away, because, again, it just felt kind of icky. But when she passed, all of a sudden it was, that picture had been in her dining room that I had seen for 20-something years. The TV stand that she had had was always beautiful. Things that all of a sudden hadn't had that meaning were things that I could have in my home and remember her by. So what I encourage you to do is write down why something is important. Write down, does it have a family history? Why it maybe meant something to you? Because again, those stories are often lost when somebody passes, and those are again the things that become emotional value when you're gone. The other thing to note is if you have a Copenbarger trust, you have what is called a memorandum power. What that essentially means is you are able to, in a letter, designate items to specific people. Why those are so important in a lot of cases, unfortunately, is because it helps cut fighting out over items once you are gone. Some of the worst and most expensive fights we have ever seen are over the stuff. And when you designate an item to a specific person, that's it. They can't now fight over it. They might have feelings about it, but legally that item belongs to the person. So again, it can help cut out those unnecessary issues that arise once somebody has passed away. One of the things we also really want to encourage, I mentioned that unfortunately now with Google and AI, one of the things we are combating the most is DIY estate plans. We see people now bring in that ChatGPT wrote this document up for me, can you review it? First answer, frankly, is no. We are not going to review an AI-generated document because there's no legal authority behind it. And very bluntly, the time it would take us to review it would cost you more than if you had just done it with us. The other issue, though, is anytime you're doing these DIY, a lot of these programs make estate planning seem very easy. That, hey, you just got to jot down who's going to make sure who manages and who's going to get it, and that's it, right? Unfortunately, especially in this state, the rules around estate planning are very, very complex, and it can come down to one word meaning something completely different. And so what we very strongly encourage is estate planning is a form of an investment in that future and that security. It is often not the cheapest thing I'm sure you would hope to find, but the reality is, as Lloyd said this when I first started, you do not know the cost of an estate plan until you need it. And that is not the time you want to find out what it is going to cost you. So again, we know that right now there are a lot of enticing plans that you can quickly hop online and do, but I truly cannot encourage people enough to hesitate and make sure that a legal professional is involved. All right. I briefly mentioned this. So with a trust, again, you are controlling the structure. You are controlling who is that manager. You are controlling who is going to inherit. Some of what you'll hear from our attorney, Mark Krause, today is on the beneficiary side. Do you want extra protection around your adult children, your special needs children, your minor children? Beneficiaries do not always inherit the same way at the same time, and in the multiple of you may have 3 children, does not mean you want those 3 children to be inheriting in an identical way to each other. So everything we do is customized. With that, I'm going to stop talking for a bit and bring up Mark Krause, who has been with us for quite a while now. Well, I won't age him, not that long, you know. But he's going to go into life planning because, as I mentioned, one of the big things is if your life has changed, your estate plan may need to. So here's Mark.
Thank you very much. I'm just waiting while David tinkers with the slides for a second. Well, good morning, everybody. Very nice to see everybody out here today. I know there's a lot of stuff you could have been doing today, and I appreciate that you took your time and spent a little bit with us, although it might have just been the free breakfast, I don't know. That said, your life changes and your estate plan should develop along with your life, as Victoria brought up. So, some things that trigger, possible changes. Your children, I always say, having kids is one stage, and then as your kids' lives change, there's a lot of, different stages. It's one thing when your kids are minors, but when your kids start to become adults, maybe it's time to start giving them some responsibility positions in the trust, or maybe the healthcare directive. But of course, there's adults, and then there's adults. A lot of times 18 is not exactly an adult these days, decision-making roles. But all these different things, and then when you have grandchildren, that's another level of planning, great-grandchildren, all these things. Also, just in addition to your kids, there could be other beneficiaries, and those beneficiaries maybe aren't alive anymore, or maybe you're no longer friends with these people. So if your children are getting married, you're getting married, someone else is getting married, your beneficiaries change, moving is another one, and we'll kind of talk about all of those. Before you move, if you do move, obviously there's a lot of reasons to stay in California, there's an awful lot of reasons to move. I'm probably never getting out of here because my wife doesn't want to leave, so, and I have a great place to work, and the weather, I don't know. Every time I have to go visit family that's out of state, my brother-in-law and sister-in-law, my wife's sister, live just outside of Houston, and man, Houston this summer is miserable. I'm always, whatever taxes we have to deal with the nonsense when I come back to California after a Houston summer, I mean, it kind of feels worth it then. So if you do move though, make sure first that your California trust is fully funded. That means that all the stuff that needs to be in your trust is in your trust. How do you do that? You can look at property tax statements. You could come see me, have me run a title report for you to make sure that your house is still in the trust. Look at bank statements. Make sure that it says, your names as trustees of the trust, or TR or something on it that indicates that that bank account is in the trust. Maybe look at your beneficiaries for IRAs and 401ks. Make sure that if the trust is supposed to be one of those beneficiaries, that it in fact is one of those beneficiaries. You also want to make sure your trustees and beneficiaries are current, obviously. So once again, if your first successor trustee is dead, that's not a great thing. So we probably want to update that. That's a good reason to update it. If your first successor trustee is someone you don't speak with anymore, that's also a good reason to update it. If it turns out your first successor trustee is in jail, probably a good reason to update that. Same thing with beneficiaries. You got to make sure your beneficiaries are who you still want them to be. And as it says down here, make sure the portfolio has current bank statements, deeds, all that kind of stuff to make sure your trust is fully funded. Not sure if this guy's more angry about somebody getting married or somebody getting divorced. Maybe he's got a step parent who doesn't like coming in, I'm not sure, but getting married and divorced are two big things in your life, and they should affect your estate planning. If you've gotten married or divorced and you haven't done anything about your estate plan, that's a big problem. So, first with marriage, how many people here have an AB trust? Anybody? A couple? It might be more of you than raise your hand, because one thing I commonly find is people don't remember that they have an AB immediately. Thank you for asking, sir. An AB trust, the basic idea is that it limits the ability, after the first spouse dies, it limits the ability of the surviving spouse to make changes, and it does so in the following way. When the first spouse passes away, the trust subdivides into an A portion and a B portion. Usually we call this a decedent's trust and a survivor's trust. The decedent's trust, all the provisions of it essentially get locked in place. It becomes irrevocable, is how we phrase it. The survivor can only make changes to the survivor's trust. And each of these trusts are funded, say, a remarriage. A remarriage is one of the really common things an AB trust is meant to sort of protect you from. If you pass away first, and your spouse finds a new hot young thing that they get, hooked up with, you might want to make sure that at least your half of the stuff doesn't go to that new spouse or even that new spouse's kids. By doing an AB trust, to make sure that your half of the stuff is protected if you pass away first, because they can change where their half of the stuff goes, but they can't change where your half of the stuff goes. There are also tax reasons to do an AB trust. If your estate is bumping up against that $15 million threshold of estate tax, then an AB trust can potentially allow you to double up the lifetime exemption. You can take the first exemption, you can take the whole exemption at the death of the first spouse and the whole exemption again at the death of the second spouse. Most people aren't too worried about that $15 million number. I wish I was. I am certainly not. I always say we're a used Honda family. Another way I explain it is, people go to Disneyland. I go, we're not Sperry Farm family. We're not really at the Disneyland level. So to have one. And just in general, it helps make sure, usually the most important reason to do an AB trust is you want to make sure that your kids are protected. This can especially be important if you have a blended family. So maybe her kids are her kids and your kids are your kids and they're not the same kids, or maybe we have all three, yours, mine, and ours. But a good way to make sure that your kids are not going to get cut out of the picture is to do an AB trust. If you have been divorced, and you have a joint marital trust with that person, as your marriage is dissolved, your financial life needs to get disentangled, right? So you absolutely need to dissolve that old trust and do a new trust. You can't just say, well, we're not married anymore, but we're just going to keep this joint marital trust. It doesn't work that way. So if you've gotten divorced recently and you haven't done anything, please use the opportunity to have a free appointment from the seminar and come see me to talk about that. Creditors, predators, and divorce. If I had to pick which three this guy falls under, but that guy looks like bad news. So, generation skipping provisions. How many people know what a generation skipping trust is? Does that sound familiar to anybody? Good, I saw a couple hands. Some of you, again, may have these provisions in your trust and not remember, or you might not have thought about it in a while. It might be a good time to think about putting them in. So what is it? A generation skipping provision is one of these tools that originally was more for deferring estate taxes. And the way that it worked is, instead of having your kids have to pay a huge estate tax bill if you were going to have to pay one upon your death, you're able to give them their inheritance in the form of a lifetime trust, and therefore all the stuff you're giving them stays in trust until they die, and it defers the estate tax all the way down basically to the grandkids' generation. That's why they called it generation skipping trust. It deferred estate tax consequences for a whole generation. Now, if you're like me, not worried about that $15 million threshold, the estate tax issue might not move the needle, and you might ask, well, then why do I care about this? We use them very commonly now, not just for estate tax purposes, but for the protective aspect that putting their inheritance in this trust has. So it's almost like setting up their inheritance in like a corporation. It's able to protect them and their inheritance from pretty much any sort of legal liability they could get themselves into, whether that's a divorcing spouse, whether that's a bankruptcy, whether that's a lawsuit against them personally. In any of those situations, if they have their inheritance set up in this sort of lifetime generation skipping trust, then it'll protect their inheritance. Their inheritance will, because it's not exactly in their name, it makes it so that they have protection against that kind of liability. So it can be a really valuable tool to make sure that your kid's inheritance or whoever is protected. Sometimes I describe it like a Job-like set of calamities. If you remember the book of Job, You could lose your spouse, lose your business, everybody turns on you and sues you. If they have one of these lifetime trusts set up for their inheritance, they can at least potentially have their inheritance to fall back on if all else fails and they find themselves in that kind of a situation. Protecting a beneficiary with an SNT. Usually this stands for Special Needs Trust, but a lot of times we use the term Supplemental Needs Trust. It's the same thing for our purposes. If you have somebody who's a beneficiary in your estate plan and they do not have any special needs provisions in there, that might be a problem. Specifically, if they're collecting certain kinds of government benefits, not simply giving them a whole big wad of money upon your death could interfere with their benefits. It could cause them to lower their level of benefits or even lose out entirely on getting benefits. And unless you do certain kinds of planning, you can make various things subject to government reimbursement after that. So a special needs trust or a special needs plan can help put somebody in place to manage that child's resources, protect them, carry out your wishes, and really importantly, make sure that that money is separate legally. Kind of like the similar thing with a generation skipping trust. It creates legal separation between the inheritance and the person so that the government can't get at it. You can say, hey, they haven't got any money. They have a special needs trust that has this money, and I've appointed, whoever, their brother or somebody, to manage that for them. But because the money is never in the special needs beneficiary's hands, it makes sure that it can't affect their government benefits and the government can't get its hands on it. So this is really important. If you say have grandchildren that might be inheriting something and all of a sudden there's a new grandchild that has special needs situations, really good reason to come talk to me. Or obviously if you have a child or somebody else in your life that's going to inherit something and they have special needs, we really need to drill down on that and kind of have a conversation and figure that out. Other special types of planning to consider. Life insurance planning. Life insurance is just another estate planning tool if you really think about it. It sets up money to go to somebody after you pass away. So this should be, essentially, like they say, although I usually think they're lying about cereal, but they always say it's part of a balanced breakfast. Life insurance can be part of a balanced estate plan. So that's something that we should talk about if that's part of your estate planning. It's a tool to use. Standalone retirement trusts, pet planning. If you have pets and those pets might outlive you, this is something that we should consider. Sometimes there's full-blown pet trusts, or there's just provisions we can put in to say where your pets go. Sometimes we can say where your pets go and leave a little money aside for somebody to take care of them. There's all sorts of things we can do, but if that's not something you've thought about and it's something you're concerned about, again, have a conversation with us about that. Addiction and substance abuse. Hopefully this is not part of any of your families or your situations, but again, if it is, if somebody who's a beneficiary suddenly develops a crippling drug or alcohol addiction, you might not want to leave them a huge chunk of your estate with no supervision rules or parameters in place, right? Probably a bad thing, possibly a recipe for them to kill themselves. So really important to think about. Again, if something like that has emerged since you did your estate plan or met with us last, schedule a meeting with us and let's drill down and talk about that. Minors trusts, there's all sorts of provisions for minors and people that just aren't quite adults, right? So one limitation of, say, life insurance planning is if that person's legally an adult, they're gonna get the money if they're a beneficiary. So if they're 18, they get everything. One thing we can do in a trust is create some delays and other rules in place so that they don't automatically get the money at 18 just because they're a beneficiary. We can have the trustee hold the money back until they reach an age that you think might be real adulthood, like again, maybe 25, maybe 35. So there's a lot of planning we can do for minors and people that just aren't quite adults yet. Remarriage protection, we already talked about AV trust. There's various things we can talk about there. Rental properties, this is something to drill down on again and consider, especially one of my colleagues, Catherine, will be talking to you later from the business department. And if you have rentals, you might want to think about doing LLCs. If you already have LLCs and you have never integrated that into your planning at all, again, that's something that we need to talk about and make sure that the whole estate plan fits together. Special needs trusts, education trusts, and just in general, all sorts of next generation planning tools. Life changes. When you have one, an email is not enough. Please don't just email me like, I don't know how many people watch The Office. Michael Scott, he just declared bankruptcy by saying, I declared bankruptcy. You can't do that. Don't just declare to me that you've changed your trust. An email doesn't work. you need an actual attorney, hopefully, to do a formal amendment to your trust if you're going to make an amendment to your trust. So let's meet about that and do an actual amendment. Don't just email me. Don't take out your pen and just write some notes and initial something in your trust or cross things out. People always ask me, if I just write in the margins of my trust, cross some stuff out and initial and date it, will that work legally? I always love giving the real attorney answer, which is it depends. So never get a straight answer from an attorney. But it really does depend. It might be a valid amendment, but you're banking on a lot of uncertainty because, first of all, maybe even if it is valid, who's to know if the person reading it really understands it? Who's to know if you even did something, who's to know if you even really understood it? As Victoria said, legal documents are complex. Estate planning is a really complex area of law. And in the final analysis, the question of is it valid could be something decided by a judge. And I'll tell you, having done trials and having done a lot of litigation, when you're talking about judges, the law is very, very human, and this is why attorneys always try to get you to settle, because even if you have the strongest case you can imagine, you never know what a judge is going to do. If they had some bad eggs that morning, if you look like their ex-girlfriend or boyfriend, all sorts of things can affect their decision-making process, and you really never know what a judge is going to decide. So we want to leave as little stuff to chance as possible when we're, and obviously, common amendments, changing trustees, changing your distribution provision, updating your powers of attorney. These are all things that we should do together. Do it validly with an attorney. Don't do it yourself, please. My next topic, staying ahead of legal changes. You may or may not know that the law changes from time to time. The state legislature, they're constantly doing something or other, and sometimes the things they do affect you. Usually, the things they do take more of your money out of your pocket. Which is something that we attorneys have to stay up on because it's just a constant pull and pull of us trying to keep as much of your money in your pocket as we can, and the government trying to find new and exciting ways to take it from you. So, one of those new and exciting ways, although it's not as new anymore, but it was at one point a new and exciting way to take your money from you, is Prop 19. How many people know what Prop 19 is? We'll get to it in a second, but I do remember when it was on the ballot, I think the pitch was that somehow it was going to put more money towards seniors and senior care, when in reality it literally just took money from seniors. Like everything. Basically, not to tell you what to vote for, but my general rule is if anything on my ballot is trying to take any money from me at all, or even take money from people I know, the answer is no. So, not to tell you how to vote, but that's the way I do it. Medi-Cal changes. We're going to talk about the Secure Act. Someone else is probably going to come up. Kevin, I believe, is going to talk later about gift and estate taxes. He's our advanced planning attorney. California tenant laws, Corporate Transparency Act, and California employment law changes. So first, as I alluded to, Prop 19. Originally, if you owned a piece of real property and you wanted to go to one of your children, it qualified for an exemption from being reassessed. That meant if you were still paying property taxes based on the value of that house or rental property from when you bought it in 1975, when you transferred it. So now it's been drastically gutted by Prop 19 such that the only kinds of transactions that qualify for that exemption from having the property reassessed are if the parent was using it as their primary residence for at least 2 years before the transfer, usually the date of death, and if the child is taking it as their primary residence. This is really important. If you just did your estate planning under the assumption that all your kids were going to get various properties and they were not going to have any increase in property taxes, that's a reason to rethink things and have a conversation with me, because we might have to do something a little different, because unless it falls into that category, unless it's your primary residence for at least 2 years, and unless that child is taking it as their primary residence, it is not going to qualify for the exemption from reassessment.
The county insisted it be the homeowner's exemption specifically for that house.
Mm-hmm.
So you might mention that.
Okay. We got down on some of those things in an actual appointment, but the basic rules I want people to just be aware of is that it has to be your primary residence for at least 2 years, and the child has to take it as their primary residence. Homeowner's exemption is something I should say about moving that I didn't mention. One really important thing about moving, if you are moving to a state that requires specific language in a trust to transfer your homeowner's exemption from California to that state, those include states like Arizona and Florida. please come meet with me before you move to that state, and we can try to help figure that out. In general, if you're going to move to a different state, it's a good idea to sit with me and have a meeting. I know that before this most recent tax deadline, I had multiple people who had moved to Florida and not told me about it, and at the last minute, like a week before, all the tax paperwork was due, they said, hey, can you add this language to my trust? And I said, well, hopefully we'll find out. So please don't put us in that position. Don't put yourself in that position. If you're going to move to a state and you think there might need to be something different in your trust, come and talk to me and we'll figure that out together. That said, if that child, like I said, the child must occupy the property as their primary residence. If they want to operate it as a rental, it is not going to qualify as an exemption-free assessment. People often ask me, how long do they have to have it as their primary residence, speaking about the child? There really isn't a clear answer to that. It's kind of just indefinitely. So whether or not the state is going to continue to keep up on things, if they use it as their primary residence for 3 years and then change it to an Airbnb, not sure, but there really isn't a clear end date for how long that child has to use it as their primary residence. So that's something to be aware of. There are things we can do in planning, such as a right of first refusal that can sometimes help preserve the possibility to put your kids in the best the best place to potentially take advantage of Prop 19. So that's something that we should talk about if multiple kids might want your primary residence, and if you want to preserve their possibility to maybe take advantage of Prop 19. As I said here, right of first refusal. There's also certain things that affect LLCs. I'm not going to get into the weeds on that. That's more of a conversation for, again, our business attorney, Catherine. But there are certain things with Prop 19 that affect LLCs. She's the person to talk to about that. Next concern, Medi-Cal. Medi-Cal is part of basically a confusing triumvirate of concepts. There's Medicaid, Medicare, Medi-Cal. What are these things? Why are they named so similarly? Well, many of you might be on Medicare. That's the public insurance option, essentially. If you're of a certain age, you're probably on Medicare. Medicaid is another federal, program that's basically, it's not health insurance, but it's supplemental money for health issues, that can be available to people, especially if they fall below a certain income threshold or if they have certain other issues. Medi-Cal is basically just Medicaid, but California had to put our own little stamp on the way we appropriate it because we're special snowflakes in California, so we had to call it Medi-Cal instead of Medicaid. But it's basically Medicaid. So, top concerns for seniors we have here, which I'm sure I don't have to tell you that these are top concerns, but just as an infographic, becoming ill, obviously very big up there, losing one's memory, being a burden to one's family, outliving your money, caring for aging relatives, outliving your spouse, and obviously everybody's worried about dying. That's kind of the general reason we're here. You should all at least be maybe not worried about dying, but aware of it and concerned about it. Paying for long-term care. This is sort of the main concern we have with regards to Medi-Cal. The way Medi-Cal sort of interacts with us is we try to help plan so that if necessary, you can take advantage of Medi-Cal to pay for long-term care. And specifically, the thing we're concerned about is being in like a skilled nursing facility. That's what Medi-Cal can potentially pay 100% for. So if someone were to develop, serious dementia, Alzheimer's, those kinds of things, or anything else that would require them health-wise to be in a full-time skilled nursing facility, how many of you, I should ask this, have a relative in a skilled nursing facility in California? If you do, you probably are aware that to pay for that skilled nursing facility, it costs upwards of like $15,000, $16,000. Easy, maybe more, especially some of the nice places in Orange County. You could be looking at $20,000 a month. Just to be clear, not a year, not every 6 months, that's a month. Like between $15,000 and $20,000 a month is very, very common if you're looking in Southern California for a skilled nursing facility. Now, if you are not one of those people who's worried about the $15 million threshold, you might realize that that could drain your estate very quickly. So you might have worked your whole life to save up a nice nest egg for your kids, and then if you have to go into that skilled nursing facility, it can go away very, very fast. So, Medi-Cal can potentially help with that. But there is a big but there, because the question is whether or not you qualify for Medi-Cal. Many of you probably do not. And the way that that gets sussed out is up here. So it's basically a strict asset-based test. They switched it in 2024 to an income-based test. So if you met with us about Medi-Cal back then, we were giving you a different song and dance, not because we wanted to, but because the state legislature changed everything. And then after we sort of shifted gears and created a trust to deal with that sort of regime, in late 2025, Gavin Newsom decided, never mind, we'll switch it back again. So now we've shifted everything back as well. So it's a strict asset-based test, and basically your primary residence is going to be exempt. So if you have a primary residence, that won't count against you. On top of that primary residence, you're allowed to essentially have $130,000 in other assets. If you're married, we can add on an additional $65,000 for a spouse. And if you have any additional household members, so if you have an adult child living in the house with you, if you have, a buddy living with you, if you have a sibling, who knows, if you have another adult member of your household, you can add an additional $65,000. But those are the limits. If you have, $300,000 in other assets and a primary residence, you're not going to qualify for Medi-Cal. So, what can we do? We can help you do that. If you've done a trust with us in the last couple of years, if you look in Article 5, I think it's 5.1D, I want to say. I do know our trust pretty well. So I believe it's 5.1D. There's a little section that says Medi-Cal Public Benefits Planning. And what it does is it gives the maximum amount of discretion that we can give to your backup trustee, which could be, just your other spouse, or it could be, the backup trustee after both spouses can no longer serve. But it gives whoever the trustee is the maximum amount of discretion we can give them to do whatever the heck it takes to qualify the person for Medi-Cal or other public benefits. And the most drastic thing that we can do right now is we can actually prepare basically a Medi-Cal asset protection trust that is somewhat cumbersome and expensive for sure. But if you need to put somebody in a skilled nursing facility, it'll pay for itself generally within 1 month or 2 months easy. It can essentially shield all the assets from the Medi-Cal qualification process and allow somebody that would otherwise not qualify for Medi-Cal to qualify. So you can essentially stick everything in this irrevocable, trust and say, actually, I don't own anything. For me, it would be like the Krause Medi-Cal Family Trust over here. That owns everything, but I own nothing, so please give me full Medi-Cal benefits. That's something that we can do. So if the first thing to think about is if you haven't redone your trust with us in a long time, like the last, 5, certainly 10 years, you probably don't have that section in Article 5. Good idea to have, and it's not that cumbersome or difficult or expensive to just add that in. So first make sure that's in place, because that preserves the possibility of someone creating that kind of asset protection trust for you, even when you can no longer consent to it. So that's number one. Number two, if you or your spouse or somebody that is important to you has been diagnosed with Alzheimer's or dementia, it's good to get out in front of it and to have a conversation about what to do about that sooner rather than later. So in either one of those cases, this is again a reason to use your free appointment to come see me and have a conversation about this. The Secure Act. Secure Act is something that is a large financial omnibus thing that affects all sorts of complicated stuff. The second half of it went into effect in 2022. The way it interacts with what I do, the only part of it I care about, is that it changes various rules for inherited deferred compensation plans. So we're talking about basically IRAs and 401ks here. So if you have IRAs and 401ks and you have the trust as a beneficiary on your IRAs or 401ks, we need to make sure that the part of your trust that tells the trustee how to deal with those kinds of plans, there's a section in your trust. The article is going to depend on all the other stuff in your trust, so I can't tell you exactly what article it's going to be for you. But there is an article in there entitled Retirement Plans and Life Insurance Policies, or some combination thereof. I think older versions might have switched the order, but there is an article in there that says life insurance policies and retirement plans, and it gives the trustee instructions for how to handle those things. If you haven't met with us in the last few years, then you're going to want to meet with us and have a conversation to potentially update that section so that we put all the correct rules in that the trustee needs to know about so that they don't incur penalties from the IRS for mishandling those kinds of accounts. But again, it only really matters if you have IRAs and 401ks and if the trust is potentially going to be a beneficiary on those IRAs or 401ks. If you have IRAs and 401ks, again, this is a reason to come have a conversation with me and probably update the trust, but at least we can have a conversation about whether or not you need to change the life insurance policies and retirement plans section of your trust. General rules, though, that you should be aware of. The biggest thing it changes that everybody knows about is the timeline with which those distributions out of that light 401k or IRA are going to be made. So in general, everything has to get out of it within 10 years with required minimum distributions, scheduled between years 1 and 9. There are exceptions to those rules if it's a spouse, inheriting the deferred compensation plan, or a minor child, or somebody that falls under the IRS's rules for somebody that counts as, having a chronic disability. So there are exceptions, but other than that, the rules about 10 years are going to apply. Yes?
Does that include Roth IRAs?
Yes. So I am going to turn things over to Lifestyle Financial, our sort of sister financial planning company, and Chaz, who knows a lot more about investing in markets and all that sort of stuff than me.
Well, good morning. I just want to say what a pleasure it is to be here with you today. So thanks for spending part of your weekend with us. I am Charles. I have been coming to these seminars ever since I could walk and my grandparents would take me. Today I'm going to talk to you about wealth and legacy, but I want to spend just a few minutes talking about Lifestyle Financial and what we do. So for the past over 3 decades, which is hard to believe, we've been helping people, families, and small businesses identify and work towards accomplishing their financial goals. So what we like to say is anything that has to do with money, we deal with it, and investing. And if we don't specifically deal with it, we know where to point you. So I get a lot of questions frequently from people, and they vary a lot. And when I was thinking about what to talk about in the presentation today, I think diversification and talking about financial planning is really important because there have been a lot of things that have been happening in the market. We've seen a lot of big moves and changes and fluctuations, and I noticed that a lot of financial planners don't talk about diversification as much. And I think there's a reason for that. Diversification is not really an exciting topic, but that doesn't mean it's not important. And there's many different types of diversification. It can mean so many things. I have a lot of people where I will meet with them and they'll say, I'm diversified. It's like, well, tell me what that means to you. It's like, well, does that mean you're 60-40 with stocks and bonds? Does that mean you're diversified as far as you're having different asset classes? There's a lot of different things that could mean. And there's a lot of reasons that's important. And so first, when it comes to assets, I think it's important that you diversify across many different asset classes. Now why is that? Well, asset classes, different areas, are going to behave differently over different periods. There's always going to be outperformers, there's going to be different asset classes that will be in the middle of the pack, and then sometimes there's underperformers. But just because one area is doing really well does not mean it's going to do well and outperform indefinitely. They rotate, they change, and that's why it's important to diversify. Real estate. We live in a wonderful, beautiful state that has wonderful weather. Real estate in California, over the long term, performs really well, but that doesn't mean we don't still see cycles where it drops and then comes back. Gold. So, over the last 12 months, I've had more conversations with clients about gold than probably my entire career. More specifically, when it was climbing up like crazy, and it was going past $5,000 an ounce. Everyone was really excited about it, especially people who had invested in gold for a long time. And now it's dropped down. It's dropped quite a bit, about more than 20% off of its highs. Now that doesn't mean gold is not a good investment, but again, it was performing, it was really hot for a little while, then it cooled down. Now, when it was climbing, I had conversations. Should I put everything in gold? My answer was no. You should not put everything in any one asset class. Bitcoin is another example. Cryptocurrency. What has effectively evolved from something that was more of a toy or a novelty 10 years ago has now evolved into something that is very real. We have ETFs, investment funds that are now investing in this fairly new asset class. There's a lot of people who are excited about it, and there's a lot of positive about it. However, that doesn't change the fact that a year ago we were looking at $120,000+ per one Bitcoin, and now it's about half of that. And so there is still volatility for a long time. I had other people ask me, should I put everything in Bitcoin? Should I put half of things in Bitcoin? It's like, well, let's talk about your risk appetite. Let's talk about, what that could look like. Because there's biases that we have. We're all human, we're all emotional creatures, and it gets exciting. Markets go up, everyone wants to participate, and we start to think, oh, well, this investment has performed well the last year, the last 2 years, it's going to keep on performing well. I want to just keep on putting more in it. And that is a danger and a risk and something to pay attention to. There's also diversification across sectors. Technology's been doing really well. You've got health sectors are going to behave differently in different market conditions. And here's one that I think gets overlooked sometimes. How many people think they can predict what's going to happen with the tax code? Good, I got some chuckles there. Nobody knows, because we're just one different administration, one different Congress away from the rules changing entirely. They're always changing. That is the only thing we know. And so, as a financial planner, I'm put in a difficult position because people are like, well, what's the plan? How do we plan the next 30, 40, 50 years, or even 20 or 10? Well, my job is to give you as many options as possible. And that's why I think diversifying across different tax buckets is important. Not just having 100% of things invested in retirement or 100% of things even in a Roth. But when you have options, when you have assets that are pre-tax, post-tax, and also just, non-retirement assets, it gives you options so that way you can take advantage of whatever tax situation you're currently in. And also time. People ask me, well, should I plan for the long term or the short term? Well, the short answer is both. You have to have things set up so that way you are prepared for both short and long term. Little changes over time make a big difference. One of my favorite concepts, dollar cost averaging. I would much rather have a client who consistently puts in and invests or does things over time. You create the habit, and then those investments grow slowly, rather than putting in a lump sum, the market goes up, it goes down, pull your money out, you got concerned. It's better to do things slowly over time. And that's how you really get that sustained wealth that lasts beyond one lifetime and then goes to generation. Now, the market's been moving a lot. We keep on flirting with new highs. It's been exciting. I enjoy this stuff, and so does my partner, Zachary Brayman. But one thing that I've noticed is every time I pull up the news, there's inevitably a headline that's doom and gloom. Expected market crash, this, that happening, things that are going on, the Strait of Hormuz. There's always negative things. But the fact of the matter is, the market's going to go up, the market's going to go down. Fear sells headlines, it sells, I used to say newspapers, but I guess we don't really use those anymore. But what really matters is time in the market. Even when the market's going down, that seems to be the time that we naturally want to pull our money out, make a big change. But if you look at it differently, if everything's going on sale, that's not the time to sell something, that's the time to buy. And the other thing, if you look at the charts, usually after 2 or 3 really down days, the following day there's generally a huge jump. And that's why mathematically it's important to highlight the fact that missing the best days hurt returns. If you pull out and miss some of the 2, 3, 4, 5 best days, that can make a huge difference. And that's generally why most retail investors will underperform the market averages over the long term. And that's where patience and diversification reward investors. That's why having a good plan, being diversified, staying the course, and not being reactive to the market. Now that doesn't mean not making changes over time, because going back to that diversification conversation, I've been having a lot of conversations lately with clients where we're talking and we're analyzing some positions, because I don't know if anyone's noticed, but technology, artificial intelligence, energy, semiconductors, these have been huge growth areas. And because of that, they have outperformed other investments in the portfolio. And even though right now it's the golden goose, they're the best performers, it's not a bad time to look at those investments and say, this has grown too much, we need to take some of this position, reduce it a little bit, and reinvest it amongst other positions, so that way the portfolio is not getting riskier than we realize, because that can creep on us too. You start out with a moderate or a moderate growth portfolio, and over time that can get more and more aggressive, and then we have a big drop in the market, and all of a sudden, wow, I didn't realize my portfolio could move that quick. Generational stewardship, because I think we're here for legacy. You have your trust with Copenbarger because you want to make sure your estate's taken care of, and your wish who had children. It's become really important to me personally, where I see like how important legacy is, and you know, ensuring that you're preparing your heirs with like financial literacy, because I guess everyone's experience may vary, but for me, when my sons turned 18, I didn't just hear a timer go off and they were instantly adults and they knew everything. But it's important to not only prepare heirs, but also trustees, because the more training, the more exposure they have, the earlier on, it's going to allow them to better handle the legacy and the wealth that has been built up. And it's also important to communicate and teach those values early. You know, this is what's important. This is what this is designed to do. You know, the trust does tell them exact instructions, but the more you can instill your values, the better. And so, why are we here? So we're here to be a resource. If you have an existing relationship with a financial advisor or a wealth management firm, we're not here to disrupt that. But if you would like to have a free review, if you want to have your portfolio looked at, it's complimentary. Sit down with us, make an appointment. We'll look at your investments, give you a checkup, give you a second opinion, and see if there's anything we can do to improve on your situation. Or just ask some questions, because sometimes there's opportunities that you don't realize until they're brought up to you. But I hope you enjoy the rest of the seminar. Thank you for coming, and thank you for sharing some time.
Well, I'm going to introduce somebody that I have been able to work with redoing his estate plan, actually, and it's somebody that I really admire. He does really, really important work on behalf of everybody in this country. He's founded an organization that I really passionately believe in, that's there to protect our rights, and really important for my kids to make sure that they have the rights that I enjoyed still with them after I pass. Brad Dacus.
Thank you very much. I appreciate that. And by the way, we are very, very pleased with what Copenbarger has done for our family and our trust. I went and, okay, I'll put one together for you. I made one little mistake, one word. It threw the whole thing into probate when they passed. And I was holding the hand of a paralegal who was bringing me through to get it out of probate. So I really appreciate high quality work of Copenbarger, and I will never do my own trust again. So how many heard of Pacific Justice Institute? Raise your hand. Okay, very good. How many get our case updates, emails, or mails? Raise your hand. Okay, a number of you do, good. Well, I founded the organization back in 1997. I know what you're thinking. How can that be? He looks so young, right? Thank you for laughing. So I saw one of you. No, it's fine. But yeah, so as it turns out, I found it, and we now have 37 offices coast to coast. We have 147 cases in active litigation. We do all our work without charge, and we defend religious freedom for everyone. We defend parents' rights against the government, the sanctity of human life, all without charge. And it's an exciting time because we have a lot of cases. And I'd say the last 2 years we have the highest success rate in our litigation in our cases. Our win rate has been incredible, absolutely incredible. And it's very encouraging to see what we're able to accomplish. You know, I'm going to give you a few examples here. I think you'll find it interesting. You know, when churches and synagogues are attacked, we go to bat for them. I know there was a synagogue in Northern California, Bay Area, and they were once told that, well, you can build your synagogue, but there's just 21 land use restrictions for just one day of the week. Guess what it was? Saturday. So we stepped in, we represented them. We got all 21 restrictions removed, which is great. We've also actually fought against some of the anti-Semitism on university campuses and colleges against Jewish students. All throughout the country without charge is what we do in that regard. We also have a lot of churches, of course. They're oftentimes they're prevented from building and growing because of land use or zoning restrictions. So we've stepped in. One was shut in San Diego area. We stepped in, it was padlocked, and we went in and we defended it. And it was technically padlocked because 20 years earlier it had been zoned to be a bar, but it never was a bar, it's only been a church. The owner of the building thought, well, switch it. He never switched it back. So the city was going to shut him down and make him pay over $300,000 in fees and fines, and it was ridiculous. We went into federal court. The federal judge said, really? City of San Diego, really? You really think you can get away with this? And ruled in our favor, and he said, take that lock off today and let that church function. And they did. When the synagogues were shut down because of COVID, remember what happened? Now, at first I thought, okay, 2 weeks, okay, I get it. Everything's all shut down to help the hospitals. But then everything else opened up except the churches and synagogues. And I say, I have a problem with that. So I don't get angry. I just sue. So that's what we did. And we went in and we took it all the way to the Supreme Court rapid fire. And the Supreme Court ordered the governor of California, Gavin Newsom, you open those synagogues and churches now. And he did. And it sent shockwaves across the country, which was fantastic. We also had a lot of people fired because of their faith and convictions against a controversial COVID vaccine, right? I'm sure there's some people in this room that can relate to that. When we went to bat, we led the nation in defending people's right to say yay or nay based on their religious convictions. And so we didn't say you should or you shouldn't. We just said you need to reasonably accommodate those if at all possible. And unfortunately, some people, some entities weren't wanting to reasonably accommodate at all, including an employee who worked from home. Yeah, actually, it's unbelievable. So we took that and we prevailed in San Francisco. We sued them. My favorite city to sue, by the way. I just get goosebumps thinking about suing them again. But we had a 7.8 seismic judgment, $1 million judgment, $7.8 million judgment against the city for wrongfully firing people in that regard who had religious convictions and not trying to accommodate them. We've also been defended a couple in Oregon who wanted to be foster parents. They love kids, but the state of Oregon says, well, you can. You qualify completely except just one little requirement. You need to alter your faith and agree to affirm and encourage. If a child, 12-year-old, says they think they may be the opposite gender, you have to affirm that and encourage that. They said, we can't do that. We can't do such a thing to a child like that. We'll contact the agency and you can have the child placed with someone. They said, no, you don't qualify at all then. And anyone like you does not qualify in the state of Oregon. And we took it to court, we lost, we appealed, and we won. So now Christians and traditional Orthodox Jewish people and others, they can be foster parents again in the state of Oregon. This is the United States I'm talking about, by the way. Somebody says, is this a former Soviet Union? That's right, we won that Cold War, didn't we? Okay. So it's a little bit of a challenge. We have a Korean spa case pending for the Supreme Court right now as we speak. And it's a big case. It's a women's Korean spa in Seattle, Christian-owned. They said, we don't want a man to go in here. And they said, the state of Washington says, you have to let a man be there, be naked in front of 13-year-old girls who are naked and their mothers. This is a no-brainer, right? But the state of Washington, this is their position. We took it on, and a long story short, we filed an appeal down to the United States Supreme Court. And we're hoping that they're going to take it up. It's a real big case. Another big case we're waiting for the Supreme Court on that we were behind is challenging Idaho and West Virginia. We helped them both pass laws saying boys can't compete in girls' sports. And now it's pending as we speak for the Supreme Court. Those laws, we filed an amicus brief to support it in addition. And we're going to see how it turns out in the next 1 or 2 weeks. But it's real important to protect our girls. It's real important. Your granddaughters. And so we're doing that and making a lot of progress. I can go on and on talking about a lot of our cases and what we're doing. But we have 147 in active litigation right now. So I encourage you all, if you can be so kind, to please fill this updated, to know what's going on, to know what we're doing. We do all our work without charge. We have the highest rating in the trading navigators of any legal organization of our kind. And we're really making a big impact. Also, we have our Celebration of Justice coming up October 17th in Anaheim at the JW Marriott. We have Emily Campagno of Fox News. She's going to be our keynote. Also, it's going to be fantastic. Ray Comfort is going to be he's also going to be participating. Todd Starnes. So if you want to get tickets, you can just go to our website. You can do that, scan that little code up there and get it. And I'm going to be in the back during the break, over there on the right, far right, corner. So feel free to talk to me if you have any questions. I don't charge at all. I'm a weird lawyer. But if you could please fill this out once again, it really means a lot to you personally. Let me say one final thing, and that's this. You guys being here is fantastic. It shows that you're being good stewards with your resources. And you're thinking about your children and your grandchildren. That's commendable, exemplary. But let me just remind you of one thing. Those riches and that wealth that you're leaving for your children is not going to be worth much if they don't have their freedoms. We at PJI are committed to making sure they keep those freedoms. Thank you very much. God bless.
Thank you very much, Brad. Like I said, Brad's a really great guy. I've gotten to know him a little bit over the last couple of years, and I will just say again, his organization makes very lean, effective use of your money. They don't have a lot of fat. They make it as lean and effective as possible, and what they do is really important. Your rights are only as good as your ability to actually defend them in court. That's the way the law works. If you sit down and don't do anything about it, they're going to be gone. So that said, I also want to talk to you today about Risher Mortuary. There's only one mortuary that our founder Lloyd has ever really had any sort of relationship with, one that he actually felt comfortable referring people to, and that would be Risher Mortuary. So I just want to say a couple words on their behalf today. As you're doing your estate planning, obviously we're in industries that overlap. They're a part of your estate planning likely should include obviously some bit about what's going to happen to your body after you pass away. I will say, if you pre-plan ahead, and especially if you purchase, get all that stuff figured out and purchase a plan ahead of time that says what's going to happen to you after you die, it's a really big relief for your family members after you pass away. Nobody has thought about these sorts of things unless they're the one that's about to pass away. So I guarantee you, your kids probably, unless they work in my kind of industry, have never thought about what mortuary to pick or what's going to happen or any of those logistics. So if you figure that out for them ahead of time, it can be a really big blessing. I will also say it can be a really good financial decision because it is, I promise you, if you are unaware, it's more expensive than you think to bury somebody and to deal with all those final costs, and it will only get more expensive. So by taking care of it ahead of time, purchasing a plan, having it in place, you're going to save a lot of money and really take a lot off the shoulders of the people that you're leaving behind. So I would encourage you to think about, engaging in that sort of planning too. It's just part of your overall estate plan for that sort of thing. And Risher is a family-owned mortuary. They're not, some big, huge corporate entity. They've been around for many years. Lloyd's always felt comfortable working with them, and so if that recommendation means something to you, which I presume that it does because you're here, I would encourage you to think about looking into Risher Mortuary. Anyway, I'm going to call up Victoria again. Thank you for your time and attention again.
Thank you. All right, I'm back. So, I'm sure we're ready for a break, but before we get to the break, I have a quick question. How many people sitting in here are Access members? Wonderful. If you have a badge hanging around your neck, you are an Access member. So, how many of you know what the Access membership program is? Not as many. Okay. So, one of the things that was started quite a couple decades ago now is something called the Access membership program. Lloyd years ago realized that a lot of families that he was talking to, they had simple questions. They had things that needed legal advice and opinion, but they didn't have somebody in their family sitting around the dinner table like his family did. And so they had to come in and work with an attorney. Well, unfortunately, coming to ask an attorney questions can obviously have a cost component. And so during the time of us serving over, I can't even imagine or believe, it's been over 43,000 clients, we realized that this Access membership program was needed, and over the years we have realized it was needed to be developed a bit more. When we started the program, it was really when we were just an estate planning firm with a small administration practice. And so it really focused on estate planning benefits, things that people would need to ask, but again, really had to do with estate planning. So it was a program designed to give people access to our time for no additional cost, give people access to documents for a discount, give people access to us coming to them if they were mobility limited. This was really crucial for people who wound up in emergent situations in the hospital and then weren't able to come and see us. And rather than them having to pay our time to come see them, if they were part of this program, it allowed us to go to them free of charge. But again, over the years, the firm has developed, and we realized that this program had not been developed to keep up with where we're at today. So what we have done for our existing Access members, we have taken your benefits, and that one-time fee you paid however many years ago still applies, but now you get an increased amount of benefits for no additional charge. So for our current Access members, please know the benefits that you have had have now gone up. But we've also now developed 2 additional tiers of the Access program. Again, rather than it being one program that really only focused on planning, we realized there were clients who may have advanced needs in business and tax, who may have litigation cases, who may have things that go above and beyond what we now call our foundation tier. The Access program is not for everybody. For a lot of people, it's people who are focusing on multi-generation planning and who are going to have more need for our involvement on a year-to-year basis. Again, I do want to emphasize for Access members, one of the questions we have received is, now that there are these additional tiers, did we lose any benefits? The answer again is no. You're in the foundation tier, you got grandfathered in, but if you find that one of these other tiers would fit more of your needs, we can discuss how to upgrade you if that becomes necessary. Out across from where you signed in, there will be what's called an Access table. It's going to have these different tiers with expanded benefits and information. It's that giant poster that was out there. But again, Access is really designed, it's right in the name, to grant people more access to us without having to worry about getting a bill every time that they needed us. So if or when you have more questions on this, we are happy to answer them today. We are also going to be doing a specific Access member webinar here soon to go into the different perks and benefits and go be above and beyond what we even talk about today. But again, if you guys have further questions on this, please come see us at the table. With that being said, sorry, I'll pause. You can always also use the QR codes. I don't know if it was mentioned at this point, but if you see a QR code in the packet, especially when it's on the slides, it means that we have done a webinar or that there is further information available online. The same can be said for Access. So anytime you see those QR codes, it means it's a free resource that you can get more information on. With that being said, I'm sure we're ready for a break. So we will take about a 15-minute break, come back around 10:40. If we haven't mentioned it already, where you signed up when you got here, you can also sign up for a complimentary consultation as a result of being here today. So back at that table, please feel free to sign up for those. The restrooms are past the little cafe, just go straight past it, and then we'll be around to answer questions. Thank you, everybody. I know. All right, we're gonna have people start filtering back in. All right, if you're able to hear me and you're not signing up for an appointment, please start to filter back in. All right, well, anybody in here have a little blue ticket that we handed you? Are any of my blue ticket raffle holders in here? Oh? Okay, perfect. All right, so we at least have a couple who could win.
All right, so some of you guys brought extra guests with you. We appreciate that. Because of that, you got a raffle ticket. So we have a drawing and a gift for that person. All right. So we have 5801509. What are the chances? Never say never.
All right, well, that is one of the perks of bringing people to the seminars, is we enter you into a raffle to say thank you for entrusting your loved ones and friends with coming to spend part of their Saturday with us, or entrusting us to spend part of our Saturday with them, however you want to say that. All right, well, now we're going to move into the second half of staying ahead of legal changes. So we are going to bring up our business, tax, and advanced planning team. You're going to hear from Catherine Grout and Kevin Vandenbroek. Say that right? And they're going to go into some of the, again, advanced components that come with the estate planning that we offer. So come on up.
Thank you so much, Victoria. I've met many of you, but for any new faces or anyone that has forgotten, I'm Catherine Grout. I'm primarily a business attorney in our business tax and advanced planning department. I have a background working for a lot of larger companies, and when I came to Copenbarger several years ago, I was very, very happy to join such a great team and family. Kevin is more of our tax and advanced planning specialization here, and he's going to talk a little bit more in depth about the second portion. Both of our sections here are going to be pretty brief and pretty high level. What I like to do, it's been a while since Mark Krause was up here discussing some of the legal changes that may or may not impact you. But I'm going to continue that discussion a little bit with a couple of additional legal changes, stuff that we like to highlight each year, stuff that changes every year, and then Kevin's going to take it over with the advanced planning section. So pretty brief, pretty quick. Before I get started, I usually like to take a poll to understand a little bit more about the audience I have with me. So because we're talking about business, because we're talking, and in just a little bit in some of this section as well, I like to know how many business owners I have in the room, small business owners, or maybe you work for yourself, you're a consultant, you have your own business. Any show of hands, raise them high, a couple. And how many, hopefully this is large, well, hopefully this is, I think this is gonna be larger, I should say. How many own second homes that they rent out, third homes, any rental property owners, any landlords? Okay, more hands, yes, but I would probably have risen your hand as well, because I consider that a small business, right? You're running a rental property. So some of the legal changes that I'm going to go over are within that realm, but I'm going to be very high level because, as you can see, this is more of a niche category. It's not going to impact as many people in the audience, but I want you to see faces, names and faces to the people that could help you depending on what your needs are in your situation. So first, we're going to actually start a little bit more with taxes. So every year we see this adjust a little bit your estate tax exemption. So right now it's nice and high, but you know it's an opinion. It's at 15 million, and that's per individual. So what we're looking at is if you have an estate valued under 15 million and significantly under, because once you start to get to that threshold, we also want you to come talk to us because assets can change in value over time and some of them can change really quickly. So if you have an estate anywhere near that threshold, you're approaching it or you've passed it, come to us because you want to consider some planning. Now, if you're a married couple, our first solution here is going to be, as long as you're under twice that, we can talk about an AB trust or a trust that's split. So we can talk about how to, or an ABC trust. So different types of revocable living trusts that can manage that and help you with your estate tax liability and exposure to that. Or if you're single, then you're just looking at that $15 million threshold. Now, if you are approaching, and this, like I mentioned, these thresholds change every year, and they change drastically, especially, well, they have been changing drastically with administration changes. So we really want to keep an eye on this because this is high historically, at least for the past 10, 20, several decades. This is a very high number. We've seen a number a lot lower than this, so if we see this come down, we're going to alert you real loud because it will impact a much larger percentage of our clients when we start to see that number come down and then that estate tax exposure kicks in. So it's nice and high right now. If you're fortunate enough to be in sort of our minority here that it impacts, Kevin is probably going to be a person that you definitely want to reach out to, and he's going to talk a little bit more about some of the strategies of what we do to mitigate that exposure in the advanced planning section. That's that's sort of his wheelhouse and where we go to try and reduce that exposure. Another highlight is just your annual gift exclusion. So this is how much can you gift a year without telling the IRS? Right now, $19,000.
Is that per person?
Per person, yep. And so but $19,000, yes, it's a big number, but let's think about it. If you're trying to help a grandchild get through college, buy a car, do something, that number, we can go past that really quickly. So if you're gifting more than that amount in a year, this year, you'll want to file the gift tax return because you'll want to be reporting that to the IRS, and then whatever overage that is, it's going to come off your lifetime exclusion, the estate tax exclusion. So those numbers adjust every year, so they'll probably be, if you come to our seminar next year, they'll probably be highlighted again and we'll give you some new figures.
Is the child required to pay taxes on the gift?
So you'll be filing the gift tax, and actually you'll be reaching out. What you'll want to do is file the gift tax return, but they won't be paying taxes on it. And I'd say if you're doing it, let's have a consult with Kevin. We help you file the gift tax return, and we cover you. Okay? Anything you want to add right now?
Yeah, I'll get going.
Okay. One other thing. Okay, so I want to cover portability, and we include this in here because of the estate tax exemption change. It's not really a legal change that we've seen in the past couple of years, but we have this amazing tool of portability for that estate tax. So if you are, honestly, for everyone, so let's say unfortunately your spouse passes away, you were under the estate tax exemption, so you have sort of this unused portion of their unused portion of their estate tax exemption. Let's say your estate was $5 million and that exemption was 15, and you have a split AB trust. So you have this unused portion of that estate tax exemption. One tool that we have still currently available is this portability. And this is likely something that you're actually going to work with the trust administration team. So once your spouse dies, you'll want to come to us to discuss this, because there is a ticking clock, but you can essentially carry over that unused portion and increase your estate tax exemption amount. Now you're thinking probably, well, at 15 million, I'm already under the threshold, I don't need it. But because that estate tax exemption adjusts over time, and we never know, unfortunately, when we'll die, we don't know what it's going to be when we pass away. So it could plummet, drop lower. You'll want to take advantage of this tool when you have it, okay? So please come and you'll be talking with the trust administration team, and we'll want to discuss using this tool. Okay, now, we had a good number of people on each side here that have rental properties, that are landlords, that manage tenants in one way or another. So I do like to just highlight really briefly. There's a lot of changes year over year in California related to tenant law. A lot of little nuances and things that you can get stuck on, and hiccups and things that can cause penalties, or things that can cause you to not be able to evict your tenants when you need to. There's a lot of little legal changes. I highlight a couple here. So in California, very tenant friendly. As some of us, as our landlords are like, yes, very tenant friendly. And I feel like each year it gets more and more tenant friendly. So if you're a landlord, you want to make sure that I'm going to start from the bottom. So this actually went into place last year. Before and after tenancy, and before and after doing any work on the property. So if you're a landlord who wants to be able to collect part of that security deposit because of damage, you'll need to have had photos before and after the tenant, before and after occupancy, and before and after work. So if you have a dishwasher replaced or anything like that, you'll need photographic evidence. Another one, so I'm going up the list. So this year, a new law that went into effect is that Social Security benefits delay is a defense. So if you have a tenant that's on Social Security and they can't pay because there's a delay in distribution of their Social Security benefits, that is a full defense. So you can't really do much there. And then another one, we're increasing or expanding habitability requirements. So especially when we're looking at ADU units, kind of with modified kitchens, maybe you have a smaller kitchenette, you need a fridge and a stove. These are requirements for the property to be considered habitable, okay? So a couple changes, but there are plenty more. These are just big ticket items. Let's see. This is not going to be in your slides, but if anyone has, I do just like to plug employment law in California also changes every year. There are new adjustments to the requirements. If you have a business with employees, didn't seem to impact a lot of people in this room, but perhaps on the live stream, or perhaps you know someone who owns a small business with employees. If they are looking for counsel, this is kind of where I like to plug that they can come to me and we can help them out with some of the legal changes that have happened, or if they need general counseling on other employment issues and making sure they have the right notices to their employees, etc. These things change frequently. They're kind of a pain because it's like a single notice that you have to make sure you give by a certain date. So please feel free to have them come to us. At this point, I'm going to have Kevin come on up and take it over, and he's going to cover the next batch of 5 or 10 slides here. Thank you.
Good morning, everybody.
Good morning.
Good answer. There we go. Good replies. Also, to everybody out there on the live stream, good morning. Make sure you hit like and subscribe, as the kids would say. My kids would be mad at me if I didn't say that. For anybody out there on YouTube watching us, I'm here to talk to us about advanced planning today and how that kind of works around taxes, advanced trust, charitable planning, business planning, all of those fun things. So, when we talk about advanced planning that we do here at Copenbarger, we break it into a couple of different buckets, so to speak. A large portion of that is the higher investment and tax advantage planning. We are looking to serve clients who have estate tax exposure, so that's going to be those of you with, a gross net worth of 50 million if you're single, 30 million married. Generally, I think the time to come and sit down and talk about possible estate tax exposure. Usually, I like to deal in like rules of thirds. So if you're about 2/3 of the way there, let's call it 10 million or so in assets, or 20 if you're a married couple. It's probably time to sit down and at least start having that conversation. And you heard why through a lot of different presenters today. Our tax laws have changed constantly in the last decade or so, even more so in the last 40 years. Prior to the Tax Cuts and Jobs Act in 2016, the last major revision of the code we saw was back in '86. For example, I wasn't born quite at that point, so I came a few years later. When I started law school, the amount that could be passed for the estate and gift tax exemption, the lifetime credit, was capped at $1 million. Well, that's not exactly true. It was always around that lower. The year I started, there actually was no estate tax because they didn't pass a law to re-up the estate tax. So there's that one glorious year, like 2011, when you could die without paying any taxes, and a lot of really rich people mysteriously died that year. Don't know why, but it happened. Starting in 2012, that's when the first kind of big revision to the estate tax laws kicked in. We saw the exemption shoot up to 5 million in index for inflation, and that's also when that portability portion kicked in. Then in the last few years, we've seen first with, it was the Tax Cuts and Jobs Act was in 2016 when we saw it raise up to the 10 million index for inflation. It was scheduled to come back down. And that was supposed to happen in 2025. It's supposed to fall from that 10 million index back to the 5 million index, but then the One Big Beautiful Bill Act, I think it's called, came along, and that raised it up to 15 million now for exemption. So we've seen basically a $10 million earmark for the estate tax exemption come in the last 10 years or so. With the constantly changing makeup of Congress, it seems where taxes were something they didn't often touch, the last several changes we've seen it touched each time. I've tried to predict it year after year after year, and now I've decided we're going to see what Congress is going to look like, we're going to see what they're going to talk about, and then I'll give you some advice, because the last few years, I was really warning clients, hey, like 10 million, it's never been this high, it'll never be this high again, it's coming back down, and then halfway through the year in 2025, they're like, here's a new bill. It's like, oh, never mind, it went up. So, anyway, the estate tax exposure can change over time is what I'm getting at. If you're in that realm, let's sit down, let's talk, let's come up with a plan. We don't necessarily need to lock assets away or do any of the fun advanced techniques I'm going to talk about here in a second, but we at least should probably be on your radar and have that out there so you guys kind of know what's going on. Next up, we love serving clients with charitable goals. Charity and just kind of community and giving back is a large value and a large portion of Copenbarger and what Lloyd has built in our firm. It's a big reason why I joined Copenbarger. So being able to help folks with charitable planning is one of my favorite things to do, and you don't need to be an extreme high net worth person to do this. Planned giving and purposeful giving is very important. I'm actually hosting a webinar on this on Thursday. I believe it's at noon. So if you have not signed up for that, I'd love to see some more faces there. But we'll go through all the different types of gifting. I know there was a gift question here a bit earlier, which I'll get to in a minute. But I'll go through a lot of that on Thursday as well. And then I have a whole bunch of blogs that are posted about it as well. And then we also like to talk about just certain types of assets and liquidity events. Whether you're selling a business, if you have like incentive stock options, and those are, you're reaching a public offering, something like that, we can help you do the income tax planning for that as well in coordination with your financial planners and CPAs. One of the big things we focus on is the estate tax exposure. There are many ways to get around having to pay the 40% death tax if you are exposed to estate tax. A lot of different forms of irrevocable trust shift assets away from the taxable estate. Essentially, to get things out of your estate for tax purposes, you generally have to lose the benefits and the control of those assets, which most of you sitting here would say, well, I built this net worth, I don't want to lose control over it, I don't want to lose access to it, then why else would I have built this? Your assets should be available to you until you pass. So through a lot of these different types of advanced trusts, we can make it so you still have some functional control of if it's a business or entities or at least your assets, And there's a lot of different ways to at least retain some of the income benefits from those assets until you're passing, and then make sure it gets to your kids tax-free. And then with the right type of planning, we can even do a step-up in basis and get them income tax benefits. So lots of different trusts and types available. There's no one right fit. Generally, the way I look at it is planning for the transfer of your legacy, especially if it's a tax transfer. It's a big puzzle. There's lots of different ways to put this. Many trusts and entities are going to have a simultaneous tax benefit and also serve a charity or church. These can be charitable remainder trusts or charitable lead trusts. These are great ways to defer income taxes. If you have a large income tax event coming up, we can actually plan for that using a charitable trust where you're still going to receive income off your assets for the rest of your life, and the charities you want to support on debt, they'll be down from the trust. We help set up private foundations where you can really establish that legacy of charitable giving and charitable planning with your kids, grandkids, nieces, nephews, and keep that legacy continuing on. Also, we set up nonprofit organizations, we help churches, and we help a lot of other tax-exempt businesses as well. So if anybody needs any help with that, please give Catherine or I a call. We'll be happy to sit down with you. Real estate assets. Catherine talked a bit to the landlords out there about the different issues that landlords are facing here in California. As you all know, rental properties have a huge risk of litigation claims. Squatters, accidents, slip and fall, structures being unsafe. Really, California is one of the hardest states to be a landlord in, because California does hold landlords accountable. When the courts really side with the tenants a lot. I'm the pot calling the kettle black here because I am a tenant, and I have, unfortunately had bad landlords over time, and I've taken advantage of these rules. But the thing is, I want you all to be good landlords and to be really well protected. So one of the best ways you can do that is by setting up an LLC. The LLC can hold your rental assets. It's going to stop liability at the LLC level. Your other assets, your personal trust, all those things will be, generally if you follow the rules, will be completely in the clear from any type of liability that would arise from your rental property. Beyond that, I think the next slide, there's it. Go back. Another reason that you may want to consider an LLC for rental properties, if you are considering transferring your rental properties to your kids or down the line of succession, we just learned a lot about Prop 19 and when reassessment occurs. Using a LLC, you can't avoid reassessment, but you can control the timing of it. Especially if you're going to be transferring assets or at least ownership of some of these entities to your kids during your life. Using an LLC, we can really control when that ownership changes, and we can trigger reassessment a lot later than if you would have just transferred an interest in the property to your kids. So it's really good to sit down with Catherine and I to discuss this. Yes, sir?
California LLCs do not protect anything.
How so?
Delaware does.
Delaware generally does, yes. California, either way, if you have a Delaware LLC and it's located in California, like say you register in Delaware, but the property's here in California. The business you do is in California. The people you are extending yourself to is Californians. A California court is going to apply California law on that Delaware entity. So the Delaware entity really helps. I like to use Delaware when I'm dealing with a larger entity, I deal with it more for shareholder protections or member protections, and it makes the governance easier in Delaware. But if we're dealing with actual California assets, there's generally not a huge benefit to registering out of state. Because either way, you're going to have to register that LLC in California as a foreign entity. California wants it registered, California wants their tax, California wants their laws enforced.
One more question.
Sure.
Do you have to have an LLC for each rental property, or do you have one LLC for all the property?
I have to give you the lawyer answer, which is it depends. It really, really depends on the situation. I have clients that do it both ways. I have one client that has 3 or 4 apartment homes that are in the same general area. Those we have under one entity. I have another client that has 5 mobile home parks. Each one of those mobile home parks, separate entity. Single family homes, if you're just, say you have 3 or 4 single family homes, the renters, long-term clients, one entity to hold all those, probably fine. It really just depends how we're trying to compartmentalize liability, and then also if there's any tax purposes for doing so. So it really just depends. Good? Perfect, you're welcome. Yes?
Is there a way to do an LLC without the license?
I'm not the right person to answer that for you. I'm going to take that note. I will research it. The next time you either see me or hear from me, I will have a good answer for you, but I'm going to let one of our other attorneys try to answer that a bit later if somebody can, okay? But that's a good point. The question was, by putting the property into an LLC, are you subjecting yourself to rent control? I believe the answer will probably be, it depends on the jurisdiction the property's in. I would imagine LA City proper is probably going to be an issue. I'm not sure on the county levels, but it's definitely something to look into, and that's a great point to bring up. You threw me, I like it. All right, the other thing that we do here in the Advanced Planning and Business and Tax Department at Copenbarger, we help people plan with their highly appreciable assets. Usually I'm working hand in hand with your CPAs, your financial advisors. It's really a team approach here. But if you have real estate, business interest, stock, something that is going to have considerable capital gains tax exposure. Whether this be the small mom and pop business you started 30 years ago and it's turned into a mega corporation and now we're ready to sell and you're ready to retire. Whether it be the Apple stock you bought for $10 a share and now it's, I used to know this example off the top of my head and now it's gotten too high for me to know. But either way, if you have a large tax event coming, we don't necessarily need to sit down to help you prepare your returns, but having a conversation with us to at least plan for this event, it's a lot easier to plan ahead of time than it is behind time. If it gets too close to the sale date and we try to do some of this advanced planning, the IRS may roll it back and say, oh, no, you're only trying to avoid taxes. There's no other purpose for this. They call it the step transaction doctrine. It's a pain in the butt. But that's why if you talk to me a few months in advance, a year in advance, we can generally help you save a lot on taxes. So if you are going to be starting a family business that lives on for generations, this is the favorite part of our practice. I come from a family of small business owners. My dad is a restaurateur. I grew up in the restaurant. I worked there till the day I left for law school. And then when I graduated law school, I was back just helping with things, doing free legal work for dad, because that's what you do. But anyway, we want to help you preserve your legacy, especially the family businesses. This is, aside from charity, I think the other great way that values are passed down generation to generation. How I learned my work ethic, how I learned to deal with my clients or actually help people, I learned that all from working with my dad for so long. We want to ensure that what you built gets passed down the way you want it to. We want to create a foundation that thrives for generations to come. This could be through buy-sell agreements, key man insurance, all the different things you need to make sure when you are no longer in control of your business, it's in the right hands and thriving properly. And then if you're going to be launching a new business venture, Catherine and I can help you really get your thoughts, your ideas, your hopes, your dreams, what you want your business to be. We can sit down and we can help you make that a legal reality. We can help you select the right type of business entity. We help you maintain licenses and registrations, branding protections and trademark, employee and HR policies. If you have a business and you have employees, even if you don't have what we call a chief legal officer or an in-house counsel, please sit down with Catherine and I, because we can at least point out the areas of concern that you need help with. We can generally help with those ourselves, or we can get you at least to the right person who can. Employees these days are creating all sorts of problems for the smaller employers. The larger corporations, they know about these things. Those of you that employ 4 or 5 people, you may be up against some rules you don't know about. The biggest one there is the California housing requirement that you either needed to elect into the Cal Savers plan for your employees, where they build some type of retirement plan for them, or you need your own plan set up through your own plan administrator. Huge fines if you have any employees and you don't have these set up. So if that is the case, please make an appointment to talk to Catherine and I, and we'll get you squared away. And that is going to wrap up what I'm talking about. Next up is going to be trustee duties, and that is going to be Mark O'Brien for you guys. Thank you.
Good morning, everybody. I'm Mark O'Brien, and I'm an attorney with our Estate Administration Department. A couple items of note. Everything that you just heard, I want you to throw that all away, okay? The reason being is, if you meet with me, unfortunately, I hate to say this, usually some type of event has occurred. Whether your loved ones lost capacity, whether someone's passed away, whether you're going through probate, sometimes whether you're going through litigation, right? Normally when you're meeting with me, it's no longer about planning, right? You've done the planning and now it's putting it into motion. And today, I'm not going to be covering a full gambit of what a trust administration is or incapacity, but I'm going to be focusing on trustee duties. Okay, bless you. And what trust, I'm going to kind of, and I don't know if any of you have attended any of my webinars, but I tend to do hour to 2 hour long, way too much discussion. So I can't spend 20 minutes on each slide, so I'm going to kind of skip to the most important ones here. Or I'll get kicked off the stand up here. Okay, so I'm going to skip straight to trustee duties. So you have named your loved ones, your friends, professionals, somebody to manage your affairs when you no longer can, right? Whether you're in the hospital, whether you can no longer articulate your desires, excuse me, whether you can no longer make financial decisions, right? Whatever the case is, or whether, or potentially you've passed away, right? Your loved ones, someone you was named is acting as trustee. And a trustee is a fiduciary. You are acting on behalf of another or others, okay? And the second you step into that role, you have, as you can see, a dozen plus fiduciary duties that you must abide by. So today, I'm going to go through some of those duties, and as you can see, some of them are very short, 3, 4, 5 word duties, but they mean so much more than that. So I'm going to kind of give a practical examples, so realistic plain English examples of what these truly mean, okay? And there are more. If you are extremely bored or can't sleep at night, I implore you to go to the State California Legislature website, and you can look up all the duties and you can read all of them and bore yourself to sleep. So we'll kind of start with a couple of them. The first is duty to administer a trust. That seems obvious, right? Do your job. Administer this trust. However, when your loved ones passed away, or they're incapacitated, or you're dealing with siblings that are fighting with you, this becomes much harder, right? Everyone grieves differently. Sometimes people will take months or years to grieve the loss of their loved one. And they may sit on their laurels and not do anything. Not because they don't want to, but because they just physically or emotionally, mentally cannot do so. So it's very important to understand that you have to look in the mirror and have a very hard conversation with yourself and say, am I the right person to do this? Can I do this? And if I can't, or I can't within a reasonable time, maybe I should step down, right? Maybe I should let the next person in line be the one to help administer this trust or make the healthcare decisions, right? Whatever it is, you have to have a true, honest conversation with yourself about where you are mentally and if you can administer the trust. Okay, so it's a little bit more difficult and nuanced than just the 4 words that you see on the slide here. Duty of loyalty. Now this comes up quite a bit, and a lot of times I get questions from people, and the question itself is a breach of that loyalty. I represent all kinds of trustees who have siblings and beneficiaries, and their questions are always somehow aligned with, well, can I do this? Right? That's how the conversation always starts. Can I do this? And it's almost always no, because they're trying to benefit themselves. As a trustee, you have a duty of loyalty to the trust and its beneficiaries, and you have to treat everyone impartially. So you could have a very strained relationship with your siblings or anybody else, and you still have a duty to protect and abide and provide for them. And that's also something that can be difficult if you're not able to objectively do that, right? Put aside your subjective feelings and objectively move forward with administering the trust, okay? Another duty that we're going to kind of cover is, I kind of briefly touched on it, the duty to deal impartially. Everyone has different needs, right? When you're administering a trust, your one sibling, your family member may need X amount, or may need this, or maybe going through a health crisis. Your other sibling may be trying to buy a new property, right? You're managing all these competing interests, and your job is to treat them all equally and impartially. And that can be difficult. So I implore you, whenever you're doing the trust administration or incapacity administration, consult with the attorney, consult with your CPA, the financial advisor, and make sure that you're abiding by these duties and making the appropriate decisions. Because one wrong step, and Elaine, our master litigator, will go through it in a little bit, one wrong step and you're in court. You're now litigating something that could have been easily avoided. And as Elaine will say when she comes up here, there's only one person that wins in litigation. Who is it? The lawyer, right? Always. And a lot of times the hardest thing to get into people's minds is there is no winner. Everybody loses except for the attorney. okay? So navigating this appropriately, making sure you're treating everyone fairly, reasonably, and justly is key and very important. Duty to avoid a conflict of interest. So sometimes I have instances where the trustee is on both sides of a transaction. I met with a client recently where he was the trustee of his parents' trust, and they both have passed away. And then he was also the trust of one of his brother's irrevocable trusts. And he was trying to do a sale between these two trusts. But how can he do that? On this side, his duty is to the beneficiaries of his parents' trust, and on this side, his duty is to the brother of this irrevocable trust. And on the one end, he was trying to set a unreasonably high interest rate that would have benefited this side, and then he wanted to accept that unreasonably high interest rate on that loan on this side. He would have been breaching the duties. Right? So there's a conflict of interest up there, and I had to tell him, hey, you're going to have to resign on one of these, or appoint an adverse co-trustee, someone who can basically co-sign this transaction. So being aware of these items, right? It could be that you're named as a co-trustee or a trustee of your parents' trust, you're named as a power of attorney for your sibling or your other loved one, and you're having to make financial decisions at a fiduciary level that are conflicting with each other, okay? So understanding that's more so important, especially if you or somebody is the responsible one, right? There's a lot of people in here who probably have come across situations in their own life or even in other people's lives where, of the 5 kids, only one of them is actually, has the financial acumen, has the responsibility, is going to be the one that honors the wishes, and they end up being nominated by multiple family members, and they have to deal with competing interests. Duty to take control of and preserve trust property. So this one is a little bit straightforward. As trustee, your duty is to go marshal the trust assets, make sure you're putting yourself on title, managing them, and preserving them. Right. A key example of this is a loved one's house sitting vacant. Right, and the house is in California, but you're a trustee and you're living in New York. Right, quite hard to protect that property. Right now, you don't have to fly out to California every week and sit in the property to protect it, but you have to make arrangements. You need to find neighbors, friends, loved ones, other people in the law, attorneys, whoever it is, to help preserve that property, right? And maybe it's selling the property quicker, getting a real estate agent involved so that they can go drive by the property, whatever it is. Squatters have become a much more increased problem in California over the last 20 years. Right? This didn't even really exist for quite some time. So it's understanding that you have to go put forth a voluntary effort, intentional effort to protect these assets. And as you see, and I like to tell people this too, some of these conflict. Sometimes trying to do one of these things will violate the other. Right? And there's no be-all answer for that. So a lot of times you have to have a conversation with your advisors to say, hey, I need to do this, but it's breaching these 3 other ones, right? And technically, a court, you could be removed potentially, or suspended, or surcharged, or penalized for doing that. So talk to the attorney before you take the action, walk them through the competing interests. It's much easier for us to say, hey, okay, we can structure this, we can be creative, than for you to take the action and have us unwind it, right? That's a much harder, much more time-consuming, much more expensive process. Duty to keep trust property separate and identified. The easiest way to say this is don't commingle the trust assets with your personal assets, okay? I see that all the time. Oh, it's, my parents and I, or my brother and I, we had joint accounts and we were doing this. No, we're not doing that. We're keeping our assets separate. The second you commingle them, you've breached it, right? You think of it almost like an LLC or corporation. When you form those things, as Kevin was talking about, you do it for liability protection. You do it so that if that entity gets sued, you get to say, nope, you can only come after the assets in that entity. You can't touch my personal assets. The second you start intermingling your personal affairs with the trust affairs, you've now exposed yourself personally. So if you're subject to a lawsuit, they can potentially come after your own house, your own assets, right? And you don't want to do that. That's very easily avoidable. By opening up the appropriate accounts, whether it's a power of attorney account, a probate account, conservatorship account, trustee account, whatever it is, you're able to make sure that it's clearly identified, it's separate, it's not a part of your own personal financial affairs. A duty to enforce claims. So if you know that there's a lawsuit that a trust can go after, you have to pursue that lawsuit. Right? It doesn't mean you have to actually end up filing limitations that I need to be aware of. And that kind of goes back to duty to administer. Right? There are some time and deadlines and statute of limitations that automatically get triggered when someone passes or when a trust becomes irrevocable. Whatever the case is, there are a lot of timely deadlines. Right? And it doesn't mean that you have to jump up that day, but what it does mean is you have to look at your own personal calendar. Understand, okay, I need to make an appointment and I need to get started on this. And if I can't, and maybe I need to reach out to that successor, get them involved, right? And just allow, or reach out to all the people involved and say, hey, I know this is on our docket, it's important, I'm busy with this, but I want to be transparent, I will take care of it, right? And I know it's not on here, but communication, transparency goes a very long way. I can't tell you how many times during a trust administration, siblings, family members had great relationships, and then 6 months after mom or dad or brother or sister, aunt, uncle passes away, the relationship is destroyed. I mean, it's that quick that these relationships sour, and it's not that someone's not doing their job, but if you're not communicating that job, or you're not being transparent, and there's not a flow of information, they won't know that, right? They're in the dark, and whenever there's money involved, right, we automatically, it's in our human instinct to think they're doing something wrong, right? And most of the time they're not, but they're not telling you what they're doing. So it's even though it's not enumerated on here, a duty to communicate, be transparent. Now I will say as an aside, being transparent, communicating, doesn't mean you have to talk to them every day, doesn't mean you have to give them every piece of information, right? I've had people ask trustees, I've had a sibling ask the trustee brother of theirs, hey, I want 20 years of mom and dad's tax returns. That was quite an unreasonable request, especially because they hadn't been filing for 10 years. So those tax returns didn't even exist. But explaining that to them, right, they were not trustworthy of myself, and they were not trustworthy of the trustee, so they went and got an attorney. And that attorney started billing thousands of dollars, and I started billing thousands of dollars just to get to the same result. Hey, there was no tax returns, you're not entitled to this, but here's what I can give you. Here's a copy of the appraisal, here's a copy of the inventory, right? Something that you can give them that tangibly allows them to feel comfortable with the decisions you're making. Duty to defend actions, kind of similar with the duty to pursue actions. If someone's suing the trust or someone's suing your loved one and you're acting as a power of attorney, you step in their place. So you have to understand that if there's an ongoing lawsuit against person A and you're their power of attorney or you're their trustee and you're now acting, it's your duty to step in their place, in their shoes for that lawsuit. And that can be quite a heavy burden. Now that's not going to affect most of you. Hopefully it affects none of you, right? But every once in a while it's unavoidable, so just being aware of that. Duty not to delegate to others. So unless it states in the trust otherwise, as a trustee, you can't just go, hey person, you do this job for me, right? You're not allowed to do that. Why? Well, from a common sense standpoint, when I've named my successors on my trustee, I don't want them delegated. I chose them because I trusted them, not somebody else that they arbitrarily chose, who I may or may not know. Or what if I know them and I just don't like them or don't want them to serve, right? That's an even bigger problem. Co-trustees. So if you've heard anyone speak at our prior seminars, you'll know that this is one of our dirty words we like to say, okay? Well, we hate co-trustees. So if you have co-trustees, it's worth reviewing your trust. Thinking about it, I know from a family relationship perspective, a lot of times people will say, here's a great example. I have one brother. My parents could have gone, hey, I'm going to name you and your brother as co-trustees. And I refused. Not because I don't love my brother, not because I don't trust him, but because I know the issues and ramifications of co-trustees. Also, from a cost perspective, when attorneys or any advisors are dealing with multiple people and you need multiple signatures, that just ramps up costs that could be avoided. Okay, but from a co-trustee perspective, they have duties to the trust, the beneficiaries, but they also have duties to each other. So if you have a co-trustee in New York and a co-trustee in California, and the California one is subordinate and not really handling anything, and they've said, hey, person A or B, my co-trustee, you take it, you run, I trust you, right? And you just kind of walk away going, oh, I've satisfied my duties. No, that's not how it works. If that person in New York is committing breaches, they are breaching these fiduciary duties, or they are mismanaging the funds, you have a duty to actively stop them from doing that. And that may or may not be feasible. If it's in person and they're breaching these, it can be quite hard for you to leave your life, which is also very busy and intricate and complicated, and go fly to New York and handle this. Right? So I would say get rid of co-trustees when you can. That's not always possible, but understanding that naming two people together, although it seems like a good idea, is rarely a good idea. So if you meet with one of our estate planning attorneys, more often than not, they're going to tell you, name one person, name the next, and then articulate that to those people. Explain to them, hey, this is not out of lack of affection or lack of love, or we don't believe you can do this, but here are the reasons why, from a cost perspective, an efficiency perspective, why we're doing this, right? And you're setting boundaries and expectations, and all of that just goes to the same concept. If you do that, you're going to minimize litigation. Duty to comply with the prudent investor rule, I'll kind of disregard that. It's just when you're dealing with investments and different diversification assets. Yes?
So sorry.
No, go ahead.
With the co-trustees, is what you're saying apply if it means that they can, co-trustees can work together or independently?
Great question. So sometimes in our trusts, it'll say either co-trustee can act independently. And what that means is they can sign and make decisions independently. However, they still have a statutory duty to run those decisions by the other person, still have a duty to get approval, and even if they have independent authority as a co-trustee, you still have a duty to stop them if they're making that bad decision. So that is a great question, because you would think that the word independent, which carries a lot of significance, would negate that, but it doesn't, unfortunately. So duty to comply with the prudent investor rule, essentially this: if you're not a licensed investment advisor, if you're not an attorney, if you're not a CPA, if you're not someone or an enrolled agent or someone who handles or manages finances for a living, you have a duty to consult with the appropriate individuals to make sure that you're managing these funds, these investments appropriately. Whether it's a brokerage account, retirement plan, rental real estate, it does not matter. Consult with the appropriate person. Because if you rely on their advice and you make a decision, you sell those stocks based on the reliance of the appropriate professional, and you later get sued, you get to defer that liability. You get to say, no, it was reasonable. I consulted with the CPA and the financial advisor, and they said sell, right? And then 3 months later, the stock market goes crazy, and what was $1 million account is now 2.5, right? And your siblings are going, why did you sell? Right? You relied on the appropriate person, which defers liability. If you do not do that, you are exposing yourself considerably. Kind of going along here, trustees' general duty to report. I covered that a little bit with the transparent communication. If beneficiaries reach out and it's a reasonable request, you have to give them information. Generally speaking, you have to keep them updated within a reasonable time frame. Right? A lot of the attorneys here can tell you horror stories, and some of you may have experienced it, where you have people that are texting you daily for information. Where's my money? Give me my money. What's going on? Right? That is harassment. They're not allowed to do that. There is nothing in the law that provides them with that right. However, you can always, like I said, being transparent, being upfront, setting boundaries and expectations goes a long way. And 95% of the time that works. The other 5% of the time, you end up having to make a meeting with myself or Greg or Megan or Elaine, and it becomes a lawsuit. And Elaine will kind of come up here and give you a little bit more explanation of that. The duty to account to beneficiaries. This is a big item. This is a requirement. When you take over, let's say your loved one has passed away and you're acting as trustee, you have a duty to provide a formal accounting to all of the interested parties. And this accounting, a lot of times I have clients say, hey, I've been keeping the books, I'll take care of this. And my answer is always no. And it's not because I don't think that they're capable or that they can't run a financial report. It's because there are statutes of limitations all intertwined with this type of report. It has to be in a court-mandated format. If it's not, it doesn't start those statute of limitations. It also, if you send this account, your own personal prepared one, and you get them to sign off, they could still sue you. They could still come back to the court and say, I'm challenging this, and if we had prepared it or you prepared it appropriately, we don't have to respond to those objections. We get to say, no, you lost out on your right. You waited too long, or you appropriately waived those rights. So being aware of that duty to account. So essentially what that means is, from your perspective, keep great records. Just keep great records, right? Keep the monthly statements for each bank account. Keep whether it's a physical file or a file in your computer that says 2026 January, 2026 February, right? With the individual banks. Keeping it organized makes it very hard for someone to claim you're mismanaging. It makes it much easier for them to claim you're mismanaging when you have not kept any records. From a cost perspective, also, if you have to hire an attorney to help you with this, it's much cheaper if you've already kept everything nice and tidy. If we are now having to go through a scavenger hunt through these records, right, that is going to shoot up our fees infinitely. And my job, and I know this may sound contradictory, but as an attorney, I don't want the fees to be high. I want it to be easy. I want it to be smooth. I know a lot of people will think, well, the attorneys love doing this. And it's like, no, I would much rather you wind up your affairs perfectly, very effectively, very efficiently, have everyone get their money timely. That's our goal, right? And there's some things that you can do to help that. Kind of lastly here, discretionary powers. I'll kind of defer on that. General powers, I will defer as well. Probably running out of time here. Is that right, Elaine?
Close.
Okay. If you would like to hear me talk for hours at a time on any one of these topics, we have a bunch of webinars that I've done. Happy to do that. I'm sorry. I wish I could take your answer, but I know I'm getting pushed off the stage here. Afterwards, if you want to see me. So that's kind of it. I'll pass it over to Elaine here. She'll scare you a little bit more than even I did. Okay. Otherwise, take care.
Thanks, Mark. Wrong right there. Litigation. Litigation is one of the problems that most people think about. If you get into litigation, there's a problem. Something's wrong. Whether or not you've been wrong or whether or not you've done the wrong. And our department's here to represent both beneficiaries and trustees. Not in the same case, but we handle things for beneficiaries when the trustees don't do all those things that Mark was listing off that have to be done. And that's one way for you to avoid litigation is to make sure you pick the right trustee. Okay? You need to look at your family, look at your friends, look at professionals, and decide who you think will do the best job. It doesn't mean it should be your older son because the firstborn, okay? It doesn't mean it should be your youngest because they're still in the house and won't get out of the basement, okay? You need to take a look around, figure out who you want. Look at that list of things that they're supposed to do and figure out, is this the person who's going to be able to communicate? If it's somebody who stays in their an introvert, they're not going to talk to anybody, and they don't like talking to their sisters, and they don't like talking to their brothers, they're not going to be the one who's going to really probably do the best job. There are professional services that you can look to, but most people choose somebody in their family, and unfortunately, I've seen so many times where they've chosen the wrong one. They've chosen the control freak, or they've chosen the crier, and they've chosen the thief. And you say, wait a minute, we don't have, there are people out there, and I think you kind of know the selfish children that, every once in a while there's one of those in the family. And they'll try to figure out how to get the most for themselves. I've got a case which has 10 beneficiaries, 10 sons. And he chose one son to be the co-trustee, trustee. No co-trustees, just the trustee. Well, he's a thief. He stole lots of money. Well, there's several different attorneys, and we decided we didn't want him, and the court would not elect any one of our clients, even though we offered them. So we now have a professional fiduciary. And you think, okay, that's cool, right? Well, not really, because in the last 9 months, the attorney and the professional trustee have billed $1.3 million. We're trying to figure out whether or not we were better off with the thief stealing a little bit, or whether or not the illegitimate fees should be the ones we go with. So Again, take your time, make sure you choose the right trustee. The other area where people get in trouble in litigation is by not putting everything into your trust. You have this beautiful trust that we've done for you, and then you have all this property that you don't put in there. And then you die, and here comes your surviving person, and the trustee, and says, what do I do? All this property isn't in the trust. And we say, well, there's two things that might happen. You might have to go through probate, which of course you don't want to, because that's really expensive. Or you come see me. And what we try to do is we try to do what's called an 850 petition, and we go to the court and we beg on our hands and knees and say, he really meant to have it in the trust. Sometimes that works, okay? I'd say 50% of the time. What is the difference? What makes the difference? The judge. Some judges, some counties, no, they don't care. They're going to get the probate fees. That's what they want. That's what they're there for, and you didn't do it right. Sometimes we win, but you got to try. So your job is to make sure that when you do your trust, that you go home, you fill out those schedules, and you put what you want in the trust in the trust. Keep your trust up to date. So, for instance, if you have 3 homes, you got 3 kids, you put in your trust, these 3, each kid gets a home, and you figured it all out, and you've given some equalization, make sure they all get something equal. Well, life goes on, and you sell a house. You sell your son's house. But you don't go back to the trust and say, here's how we're going to work this out. You die, and they get the trust, and daughter 1 goes, I get that house. Daughter 2 goes, I get that house. Son goes, where's mine? You don't get one. Well, do I get some extra money? No, it doesn't say that. It says the money in these bank accounts is divided 1, 2, 3. Too bad, so sad. And it really, there's nothing much people can do about it, because we can't really show that there was any other intent. The only house he was to get was the one that was sold. Another time people have a problem with that is banks don't like to lend for some reason to trustees when a piece of property is held in trust. So they say, take it out of trust. How many people have done that? I'll bet some of you have taken it out of trust to refinance. Well, a lot of times it happens, and we forget to put it back in. So just remember, when you're dealing with your trust, to keep it updated. Come see the attorneys here, every couple of years, and have your trust reviewed. There's constantly changes. It's a time to take a look at what's happening in your family and what's happening outside of your family. And I'm going to give a push and tell you that the type of things that we handle are contract disputes, elder abuse, personal injury, wrongful death. So if any time any of you have what you think is a legal question or maybe a lawsuit, feel free to give me a call. My department will talk to you, half hour, free, no charge. And if we can't help you, we can refer you to somebody else who can help you on anything. But I'm going to tell you and go back to the idea of thinking about a trust. I've got a situation with an elderly man. He's 92 years old. And he's got a lot of money. And what he did is he thought, well, I've got bank accounts, and I put a pay on death person on my bank accounts. And then he thought, I need some help, so how about my son who's in the process of getting divorced, he's living alone, he'll come and live with me in my house, I'll give him the house, he can look after me, I can stay there until, I die, it'll work just great. Well, what he didn't plan for was his son dropped dead on a tennis court. And now the son who he thought was getting a divorce wasn't divorced. So that house that he gave his son where he was going to live for the rest of his life now belongs to the essentially an ex-wife, a wife who didn't like him, but who was not yet an ex. So the house is now occupied by her, and her new husband and a bunch of kids that aren't his. He's now living in an assisted living apartment. His daughter shows up and says, I'm here to protect my money. And she has tried to go through and make him change all his bank accounts so that they say somebody else's, her name as the pay on death. And when he resisted, she's brought him in to get a conservatorship. So now I'm fighting to show that he's mentally competent. He is, but he's 92 years old. He doesn't need this hassle. If he'd had a trust, most of this would have completely been avoided. Completely been avoided. And in your trust, you have an opportunity to choose who you want to be the person who steps up if you mentally can't do it or physically can't do it. Be sure to choose wisely. Just look around and figure out who you would like to do that. Our litigation department is there for all of you for any times that you have a problem. So if you're coming to us with a litigation matter as a trustee or as a settler or as a beneficiary, if the trustees aren't, you're a beneficiary under a trust and your brother's not doing what he should, come see us. We'll write a letter, we'll file a lawsuit, we'll do what we have to do. And we're generally successful at it. So again, if I can't help you, if somebody in my department can't, we'll find somebody who can. And I'm going to invite Victoria back up here to talk about who you might want to refer to our firm. I tell you to refer everyone, but she may have some other ideas. Oh, it's a good answer, is it, Victoria? Good. Well, as I said, my department will talk to you free, first half hour, no problem, and we'll figure out whether or not we can help or send you in the right direction.
Thank you so much, Elaine. Oh, all right. Well, she was spot on. If you think anyone who couldn't be here today could use our help, please feel free to send us pretty much anyone and everyone. We're very happy to talk to people, get them in front of the right person. We also are always happy to go to different interest groups, religious organizations, and put on specific seminars and webinars for them as well. Because we do know not everybody has access to events like these. Not all attorneys are putting events like these on, so we're more than happy to help educate anyone you would like us to. All right, let's do a little housekeeping before you guys get to enjoy the rest of your weekend. If you would like to book an appointment and you didn't already do so, we do still have appointment slots that are out on that table. If you're not ready to, but you would like us to reach out, those green sheets that are in front of you at the bottom, there is room to mark if you do want us to reach out to schedule an appointment. Again, as a result of being here, you get a complimentary consultation. One of the things also with those green sheets is it lets us know how we did today. So we would love to have feedback from you on how the event went. Were there specific topics you were here for? Are there things that you would like more information on in the future? And just overall how we did. We would also always love if you can give that feedback online, especially if you've worked with one of our attorneys. It's how we help show other people the services that we have provided. So if you're able to do Google or Yelp reviews, those are always extremely appreciated as well. So thank you guys for being here today. We look forward to working with you and enjoy the rest of the weekend.